I was just wondering, to go to another county.
We'll call the case
2 hours
first.
away. So if it's.
You just have
possible-
one case?
Oh, 2 cases that I was assigned for.
Okay. Are the people transported? Are that,
I do not
what
know.
are your,
Your Honor.
what are your class name?
Roman Garcia and Quijano.
Both out of custody.
Do what?
They're both out of custody.
Okay. Okay, we'll call them first.
Thank you.
I don't see them on what number though. Yeah.
14.
Commonwealth versus Garcia. Mr. Garcia. Miss Garcia.
Your Honor, I can't speak to her whereabouts currently.
Pardon?
Your Honor, I'm not sure of her whereabouts currently. If we could call the case back, I'm hoping that she will arrive.
Issue a bench warrant for Miss Garcia. Jose Cujero. You say I'm not too good at it.
Well, me neither.
Well, I've heard you speak it.
Well, like you said, though, I got a country accent.
Yeah. It's this country though, I guess, you know. Jose, could you state your name?
José Luis Hernández Quijano,
José Luis Hernández Quijano.
Were you born in 1984?
¿Nació usted en el 84? Yes.
We're here on 24 CR 031.
24-6R-0031.
sí,
Yes.
For a pre-trial conference.
Sentencia previa al juicio.
I'll have to say.
We made our last offer, I believe the opinion, it's my last.
Okay.
What's come around here?
Eso normal a una oficina.
The charge is bribery of a public servant.
Tell me something about it.
And evidently, Mr. Garcia was in a, then he was charged with DUI. There was alleged bribery with the officer. Then the main hangup on the case is the terroristic threat, where he threatened the officer and his family and things. So that's where we are.
Great.
Judge Bob may address the court quickly on this situation.
Absolutely, and you don't have to do it quickly.
Thank you, Judge. Judge, we have been made an offer. It's a diversion offer. It's not a bad offer, and if it was someone else, I would accept the offer.
Well, maybe you ought to get another lawyer.
Well,
You're a different defendant.
well, the problem is, Judge, the immigration situations and circumstances, they was wanting him to do 30 days in jail. I explained that to him. We had felt that they would put a hold on him. He would be deported.
Who would put a hold on him?
INS or ICE are putting holds on a lot of my clients at this time. They've deported probably 10 in the last,
I was looking at probation parole officer. I mean, are you experienced in that area?
Yes, Your Honor,
I'm shocked. I
he,
didn't know that.
yes, sir. And he's got 5 children here, American-born children. He works, he's got a good job. And we wouldn't mind to do the offer, but the ramifications of that will be much further reaching than what the actual plea is. And that's the only reason we turned
I
it
think
down.
Mr. Bell's hands are tied in this case and my hands are tied because the officers insisted on jail time because of things that Mr. Quinones allegedly said. And so that's the reason if we can't get the jail time, he's wanting a trial officer.
And we did, we do 6 months home
And
incarceration.
I went back and talked to him.
Okay,
So I don't know the
So your hands
answer.
is tied in my hands.
Yes, sir.
okay.
Jan, aren't you told previously that they need a certain lead time on trials for interpreters?
It says. It's in 3 weeks advance.
Oh, is that all? Okay.
Problem.
I knew one time they didn't have one available.
But also after the election, you probably wouldn't have to worry about it.
That's true. That's true.
Well, it's looking
I have
my
no-
opinion.
I have no objection to that, Judge. Because that may very well be true.
Only reason they're doing it now is it's trying to get away.
That's
Okay,
exactly
let's,
right.
uh. Let's go out to December. How about December the 10th?
That's fine with me, Your Honor.
That's fine with me, Judge.
Let's do it the 11th. Let's do it the 11th.
That's fine also.
They got district court here on Tuesday, right? Let's do it the 11th.
I've got jury trial set on the 11th.
Where is that?
Well, I've got 1 set in Barron and 2 set in Hart. And
Okay, well, we do it on 10th then.
thank you, Judge.
Got 3.
all of them over, so this boy here won't ever resolve.
No. Not in this election changes funds.
This one won't resolve.
Okay, when do you want another pretrial?
I'd like to investigate.
We have one in November here.
Okay. November 14th. Sir, you should be back here on November 14th for a pretrial, and your trial date is set for December 10th. You may continue on the same bond.
December or November.
Yeah,
Can you call Isabella Costado next year on the AG's office? You know,
okay. This finishes you, correct? Your other client did not come in, so you're excused.
He's free to go.
Yeah,
Isabella Costado.
okay. Commonwealth versus Isabel Costado.
Her last name.
Good morning. Commonwealth versus Isabel Costado, 24 CR 0052. Are you Isabel Costado?
Yes, sir.
Born in 2000.
Yes, sir.
Last four digits, social security number 5160.
Yes, sir.
Where is your attorney?
I apologize. This is a conflict to our office. She's been and assigned an attorney. If we could have a few minutes to try to track her attorney down.
She advised yesterday, Your Honor, that she would be here.
That she would be here?
Yes, we have actually worked on Plea.
Okay, well, why don't you see if you can call her attorney and we'll call it back up as soon as we. Okay? You can just have a seat. They're gonna try to find your attorney, okay? Commonwealth versus Richard Burge. Good morning, Mr. Burge. This is 19 CR 0025. You are Richard Burge, born in 1982.
Yes, sir.
Last four digits of social security number 6766.
Yes, sir.
Okay, we're here today on a probation revocation. What does the Commonwealth have to say?
Your Honor, Mr. Burge has 6 years on wanton danger. First, he was arrested in Clay County, Tennessee on July the 8th for DUI third. He entered a plea of guilty to DUI first on July the 10th, 2024. So the Commonwealth's requesting revocation based on that new DUI conviction.
Y'all want to stipulate to that?
No, Your
Get behind the podium.
No, Your Honor, we'll need to have a hearing on this.
On the DUI, do you stipulate the fact he was convicted and pled guilty on?
Your
DUI?
Honor, with
You-
regard to
you
the DUI,
Stipulate to whether he pled guilty to the DUI and then we can have a hearing.
yes, Your Honor, with regard to the DUI, my question is actually something with regard to the probation itself.
Okay, well, so I mean, if we have, there's no reason to have a hearing on the facts, you want to argue the law, correct? Okay, that's okay. He stipulates as to the conviction. You go ahead and make your argument then.
Your Honor, with regard to the 19,
Because it's the 20.
Your Honor, with regard to this case, just for, so the court is aware, this was filed under a 19 CR case. I have spoken to the Commonwealth. I believe he's off probation for the 19 CR case. It is a 21 CR 88 case that it should have been filed on. And we have an understanding between the parties that that would be the time that would be at issue.
Is that correct, Mr. Doctor?
That's correct.
Okay, what is 21 CR what?
88.
00088? Okay,
We will inadvertently left that number off our motion.
okay. Go
And
ahead.
Your Honor, with regard to making my argument in lieu of revocation, I would ask to call my client to testify.
Absolutely. Raise your right hand, sir, as best you can. You swear a testimony you're about to give us the truth, the whole truth, nothing but the truth. Listen, you may proceed.
Thank you, Your Honor. Mr. Burge, can you tell the court how long you have been, how long you have been clean from substances?
Yeah, I've been clean set for almost 20 months, other than that DUI I got. And I failed a drug test at the Mark Center. Other than that, I've been clean since then.
Okay, and when you say at the Mark Center, approximately when was that?
It was, it's been right at 6 months, something like that.
Okay, and since that, have you completed
Since what?
since the failed,
Since the DUI?
no, not since the DUI, Your Honor,
Okay,
since the failed drug test,
previous failed.
previous, yes,
Okay.
the 6 months ago. Have you completed treatment anywhere?
Yeah, I completed the Isaiah House.
Okay. And would you explain to the court what it is that you're asking for in lieu of revocation?
I was asking for a sanction or something, you know.
Why?
I mean, I got pulled over in Salina on my bike for no helmet. And I was down there I've got a bunch of pigs down there at this old man's house that, he's been taking care of for me for the last couple of years that, I've been in rehab. Been in rehab for almost 20 months altogether. About 13 actually. When I left from there, I didn't have my helmet on, and I took like 3 shots of whiskey. And, a cop seen me without my helmet and he pulled me over, you know. I pulled over for him and cooperated with him and everything. And he got me for DUI because I took him 3 shots of whiskey.
And with regard to the resolution of that DUI in Tennessee, what is it that you're required to do?
I come to court and they put me in jail.
And
That's all I really know.
after you pled guilty, what was the sentence?
I'm on a year's good behavior probation down there. I owe a $350 fine and some other fines.
Was that a DUI,
The DUI is a misdemeanor DUI.
second or third? What was it?
It's a misdemeanor DUI.
Is it the first DUI that you had?
It is ever since 2019, I think, something like that.
And if the court were to allow you to remain on probation, would you be working a job?
Yes, ma'am.
Okay. What
And
kind
I
of,
plan on doing my DUI classes and stuff too, because I was actually supposed to went the very next day and took care of that and went and got my driver's license. Because I just had completed all my classes for the DUI in 2019.
and if the court were to give you another opportunity on probation, what is it that you would do different?
Get a job and work, you know, and quit drinking.
I understand. Is there anything else you think that the court should know?
That's it. Yeah.
Thank you. I have no further questions.
Talk, please. You want to come around and make your argument? You stood to your left.
Your Honor, I've had this job for a while and I've dealt with Mr. Burge for a long time. And I like Mr. Burge, but his substance abuse problems is going to get the best of him some days. We're all not going to live forever. And I hate that he's going through this, but the Commonwealth takes seriously somebody getting a DUI while they're on probation. This underlying case was a wanton endangerment case, DUI, where there's an abandoned vehicle and him and his girlfriend allegedly ran off from the law. So I'm sure he's sincere on what he says today, but there's got to be consequences for their actions. And I would just ask that you be incarcerated, you know, because of the DUI guilty. Being drinking and everything else while he's on probation.
Okay, you have anything else you want to add?
Your Honor, I've just asked the court to not revoke Mr. Burge.
Well, you know, there are 2 things, Mr. Burge, that really get me about worse than anything else. One of them is somebody that has a DUI, wanton endangerment associated sort of DUI. We let them probate and they get out and do it again. I'm always afraid I'm going to pick the newspaper up and find out that somebody like you that's out on probation runs over and kills themselves. And I run into their family down in Salina or out here at Walmart or something, and they ask why we didn't try to do something about it. Or you run over an innocent person. Every night on the television, we see where innocent people are run over. I'm not saying you're a bad person. You're just a person that's out of control and will not comply. So I'm going to revoke you on this thing, and you'll be out before you know it. If we parole board in all probability, and then you'll be on parole, and maybe you can live up to the parole then. Okay. Thank you very much. Stacy Eden. Stacy Eden. Commonwealth versus Stacy Eden, 23 CR 0051. You are Stacy Eden. You're here for sentencing. You get an opportunity to look at pre-sentence investigation report done by probation and parole.
Yes, sir.
Is it substantially correct?
Your Honor, there is an error on the PSI on the section that lists criminal
You need to get
history.
behind the microphone, speak up a little bit.
Yes, Your Honor, on the section that lists Ms. Eden's criminal history, there is a 2013 terroristic threatening charge
page
that
is
they have
it on?
attributed to her. It is on. I apologize, Your Honor, this is out of order. It's on the section that says criminal history.
I got it.
That
Go
is
ahead.
actually her brother's charge. She was the complaining witness.
Which one of the charges?
The 2013 terroristic threatening.
I don't see it, 2013. It says assault, first degree domestic violence pending. Are y'all looking at it?
How I left my PSI, the office, I usually destroy those after the sentence.
You wonder if I can
Right.
approach?
Come on up, Mr. Doctor.
Section there.
The very
Marion
first line,
County. Yeah.
terroristic threatening 33.
Oh, 2013.
Okay.
So you need, that needs to be deleted.
Yes, Your Honor.
Okay, we'll take care of that. Okay, is there any other reason why she should not be sentenced?
No, Your Honor.
Upon plea of guilty to assault first degree, mentally ill pursuant to 504-150 subsections 1 and 2, she shall receive a term of 6 years, credit for time served, and will waive the court cost. Okay.
Thank you, Your Honor.
Anything?
It's. Yeah.
I said 10, 10 years, 10 years. Yeah. Trina Hawkins. Trina Hawkins. Waiving court cost on, you see, because of length of. Commonwealth of Kentucky versus Trina Hawkins. Are you Trina Hawkins?
Yes,
Good
sir.
morning.
Good morning.
This is 24 CR 0073. Were you born in 1976, Ms. Hawkins?
Yes, sir.
Last four digits, social security number 8531.
Yes,
We're
sir.
here for a pretrial conference. What do y'all have?
Judge, we're entering a pretrial diversion.
A motion has been filed, Ms. Hawkins, that says you wish to enter a plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person just identified in 24 CR 0073?
Yes, sir.
Is your judgment impaired today in any way?
No, it's fine.
Okay. Have you discussed these charges with your attorney and are you satisfied with her advice?
Yes.
If you review the evidence the Commonwealth has against you, you feel like you're fully informed about your case.
Yes.
You have certain rights under the Kentucky and United States Constitution. You do not have to enter a guilty plea today. And I'm going to go over those rights. At the end of them, I'm going to ask if you understand them, okay?
Yes.
You have the right not to testify against yourself. No one can make you say anything. Right to speed trial by jury, right to be represented by counsel at your jury trial. Right to call and cross-examine all witnesses, confront and cross-examine all witnesses, call testify against you, right to call witnesses yourself, have process issue to compel their attendance. You have a right to appeal this matter to higher court if you lose, and right to require the Commonwealth to prove beyond a reasonable doubt you're guilty. You understand that entering a guilty plea today, you give up those.
Yes, sir.
Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. In the event that I do not accept the Commonwealth's recommendation and deviate to impose a harsher sentence, you have a right to withdraw your plea and proceed to trial. I'm going to ask you, it's been in your motion says that there's going to be a recommendation of a pretrial diversion. Before we get there, I'm going to ask you, have you had a pretrial diversion in the last 5 years?
No, sir.
Have you had a felony in the last 10 years?
No, sir.
Are you presently on probation?
No.
Okay, and do you understand if you successfully complete the diversion program, the charges will be dismissed, pretrial diversion, you get your record expunged. Do you understand that?
Yes, I do.
If you do not successfully complete the diversion, be brought back and forth from the court, and the court will decide if you're going to revoke pretrial diversion, schedule a hearing, and then you'd be a convicted felon subject to having another felony in the future's sentence enhanced. Do you understand that?
Yes.
Ms. Gordon Anderson, will you come around? You step to the left, ma'am.
Yes, Your Honor. Upon a plea of guilty to flagrant non-support, the defendant shall receive a sentence of 5 years, pretrial diverted for 5 years. Diversion shall be supervised until all flagrant non-support is paid in full. The defendant shall pay flagrant non-support in the amount of $100 per month, with first payment being due on October the 1st of 2024, and each subsequent payment being due on the first day of each month thereafter, and paid to the Monroe County Child Support Office, IVD number 000-423-9407. The balance of flagrant non-support shall be due at the end of the diversion period. The defendant shall receive credit for time served. The defendant shall obtain gainful employment or do a minimum of 30 hours per week until gainful employment is obtained.
Ma'am, is that what you agreed to?
Yes, sir.
Are you pleading guilty because you did commit the acts charged in the indictment?
Yes,
Are you doing so of your own free will?
Yes, sir.
Knowing your constitutional rights, without explaining to you still your desire to go forward and allow the court to fix your punishment. Is that your signature on the motion offer?
Yes, sir.
Okay, I'll accept the agreement and sign it. Court costs you what? Court costs you $185, and I'll let you pay that at $30 a month. The first payment starting 30 days from today, and $30 every month after that. You need to meet with the probation parole officer, okay? What? Yeah, you're gonna be released today. Is that okay, or you want to stay another day?
That's fine.
Okay. Nicholas Howland. Commonwealth versus Nicholas Howland, 24 CR 0041. Sir, are you Nicholas Howland?
Yes, sir.
Were you born in 1998? Last four digits, social security, 9453. You're here today for sentencing. Have you had an opportunity to look at the precinct investigation report and the probation parole? Counselor, is it substantially correct?
Yes, Your Honor, there was one major mistake, and we've already conferred with the probation and parole officer. His diversion in his other case was not voided, and they know of that mistake. They're going to correct that. And also, for the record, Your Honor, when we took the plea paperwork itself had some mistakes in it. We've corrected that, re-signed these, and have signed a new order on the revocation.
What mistakes do they have?
And we've got that corrected, and
What is the correct restitution amount?
$2,700.
Yeah, $2,750.
Okay, Commonwealth agrees with that.
Yes.
See, it was blank on mine, so I just wanted to. Okay. Okay. Is this, so you've agreed to this pretrial? I mean, on the sentencing, you agreed to pay the restitution. Was the probation to continue until the restitution was made? Okay, you understand that?
Yes, sir.
Okay, what's the court cost in this case?
And Your Honor, I'm conflict counsel. We possibly asked to waive that, but because he is making
Is
restitution.
that your signature on there?
Yes, sir.
And he has,
$215. I'm gonna let him pay it $30 a month. Starting 30 days from today, so give you a little time to catch up. Okay?
yes, sir.
That's fine.
Okay. Okay, you need to meet with the probation parole officer.
How much do I gotta pay a month on my restitution?
What was that?
Nobody ever told me. How much do I gotta pay a month?
How much?
Look at the paperwork, and see if it has, it was blank on mine.
restitution?
$150.
$150 a month.
Can you do that?
Yeah.
Okay.
Between that and court cost. and-
Yeah, the court costs, but court costs will be off in 6 months, you know.
I've had paid off in
Okay,
a month.
okay, we need to make the probation parole officer, he's standing right there.
Thank you, Your Honor.
Yeah,
Yes. And he will be released today, Your Honor, correct?
you want out, don't you?
6 months is a long time arresting my kids.
Okay, well, you don't ever have to go back again.
No,
Right.
I'm done with this.
Okay, I hope you are.
Thank you, Your Honor.
Thomas Ludwig,
Miss McCall here.
Thomas Ludwig.
What? Okay, I'll tell you. What you would think. We'll take care of him.
Are you Thomas Ludwig?
Yes, sir.
This is 20 CR 0083. You born in 1971. Last four digits, social security number 2886.
Correct.
You're here on a probation revocation. What does the Commonwealth have to say?
Your Honor, it's my understanding he was on supervision. He was an interstate compact, if you supervise the Tennessee, because he didn't register down there, they asked that he bring the vote. We had a hearing last month, and I think you said if you've got a placement up here, you would release it. That's where we are.
Yes, Your Honor, and I have an update with regard to that. Your Honor, my office has been working to find a place for him to live that would line up with the requirements of registration within the state of Kentucky and also employment. Your Honor, we would ask if the court would grant us one more opportunity to be able to find that. Our resources are limited, but I did speak to my alternative sentence worker late yesterday afternoon, who indicated there was one more avenue that we could pursue that may lead to housing that he could live at, but also could set him up with a job and other resources that he would need.
You want to just pass it the next real day? We'll give you a chance to find some place.
Thank you very much, Your Honor.
Okay. That would be October the 8th. October the 8th. If you find someplace, we can do it by agreed order. If the Commonwealth's satisfied from it, okay?
Thank you very much, Your
I
Honor.
think the AG's office, Mr. Costado, Ms. McConkey.
Isabel Costado.
You know.
Commonwealth of Kentucky versus Isabel Costado, 24 CR 0052. Are you Isabel Costado?
Yes, sir.
Were you born in 2000?
Yes, sir.
Last four digits of your social security number, 5160.
Yes, sir.
Now, is this a diversion or a felony plea?
Felony plea, Your Honor.
Okay, I'll get down to that in a minute. A motion's been tendered, says you wish to enter a plea today. Is that correct? Okay, you stepped up at the microphone.
Yes.
Do you wish to enter a plea today? Have you
Yeah.
talked to your attorney about this?
Not actually, not to my attorney.
Okay, well then we're not gonna do a plea.
Ms. McCullough's on Zoom.
Ms. McCauley, why aren't you here? Your client says that she hasn't talked to you.
Judge,
Why are
we
you
tried to get a
not,
hold of her.
why are you not here today?
First, Judge, I want to apologize for that. I was supposed to have a 5-minute hearing this morning before I came your way, and it turned into a 2-hour long, we're now still in the middle of it, on a termination case. It was supposed to be agreed to, and it ended up not being. So unfortunately, the judge here said he wanted to go ahead and have the hearing today since everyone was here. And so I got stuck here with Judge Spalding. All I can say is I'm sorry for that, Judge. I don't know. I don't have anything else I can say. He let me have a break to let you know what was going on. But as far as Ms. Costado, we've talked to her about the plea agreement. I thought we had an arrangement. I was going to be there today to take care of finalizing all that, but could not make that happen. We didn't get the paperwork until last night after hours.
I'm just looking aside, so I won't say
Okay.
anything. What did you rather do? Did you rather try to do it this afternoon sometime, or did you rather come back again, or what? I know you'd rather do it now, but I don't feel comfortable that the defendant has not had an opportunity to look at the plea papers.
Right. We can, go ahead, you said it.
Now, there's some great barbecue in town. So go out here and get some barbecue. Have you out
It's
here?
his lady's birthday, Your Honor, and so I
Well,
think she ought to be able to.
I think the Commonwealth Attorney's Office ought to buy her the barbecue.
Well, I'll be glad.
Would you rather do it another day?
Well, if we did it today, when?
What time can you be here, Ms. McCauley?
Judge, I could be there this afternoon for sure. I've got to finish this hearing here, is my understanding of
Okay,
where
well,
I'm stuck.
let's see if you can be here by 1:30.
I can be there by 1:30, Judge.
Okay, we'll do it at 1:30. And you might have to spring for the Commonwealth Attorney's, Assistant Attorney's birthday lunch today.
I'd be happy to do that, Judge. It's my fault.
Okay, young lady, will you be back here Or
Yes,
1 o'clock and and that'll give you 30 minutes. Your client's gonna be here at 1 o'clock, so maybe give you 30 minutes to go over it with her, okay?
Understood, Judge. Thank you.
Thank you. Thank you. Yeah,
Please.
sure. Which one of them?
This one.
Okay, what you got?
Only call that was on here at 9 is here, so I stayed to see if he wanted to come do that case, etc. This morning, I'm sorry, Miss Garcia.
Sure. Let's do Miss Garcia. Commonwealth versus Garcia. Withdraw the bench warrant. Commonwealth versus Garcia. 24 CR 0032. Ma'am, would you state your full name?
Jessica Roman Garcia.
Jessica Roman Garcia.
You need to look into the microphone there and speak up just a little, please.
Jessica Garcia.
You born in 1993
Yes.
and you do
No.
not have a social security.
No,
83?
83.
83?
No, 93.
What's
No,
your
not
year of birth?
83. ¿En qué año nació?
1993.
1993.
That's what I thought I said
Pensé que
1993,
dije
so.
93.
Usted me dijo a mí 83.
No, you said 83.
Okay, well, I'm at, she lost 10 years there. You hadn't been here all any time. You already lost 10 years.
10 años. Le quité.
You're here for a pretrial conference. What does the Commonwealth have to say?
Pre-trial diversion, plea.
A motion is being tendered that says you wish to enter a pretrial diversion today. Is that correct?
Ahora entrar en un acuerdo para una condena alternativa, ¿cierto? Sí. Yes.
Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given?
Declaración libre y voluntariamente. Sí. Yes.
Ms. Garcia, are you the same person named in the indictment?
Declaración formal.
¿Me repite la pregunta?
Would you repeat that
Are you
question?
the same person named in indictment 24 CR 0032?
Formal 24 CR 0032. Sí. Yes.
Is your judgment impaired today in
¿Hay
any way?
algo que impide su juicio en este momento? No. No.
Have you discussed this matter with your attorney and are you satisfied with her advice?
Con el consejo que ella le ha dado. Sí. Yes.
Have you viewed the evidence the Commonwealth has against you? Do you feel like you're fully informed about your case?
¿Cree usted que está cabalmente informada sobre su caso? Yes.
You understand that you do not have to enter a guilty plea today.
Hacer una declaración de culpable hoy
You have certain rights under the Kentucky and United States Constitution.
de los Estados Unidos como del estado de Kentucky.
Before I can accept a plea, I need to know that you understand those
Una
rights.
declaración de culpable y necesito confirmar que usted entiende cuáles son sus derechos constitucionales.
You have a right not to testify against yourself. No one can make you say anything.
Nadie le puede obligar a hacer ninguna declaración.
You have a right to a speedy trial by jury,
Público, sin demora, por jurado,
to be represented by counsel at your jury trial,
presentar por un abogado durante su juicio.
to confront and cross-examine all witnesses called to testify against you,
Que viene a presentar testimonio en su
to
contra,
produce
de
evidence,
presentar pruebas
to call witnesses in your favor,
de defensa.
to appeal this matter to a higher court if you lose,
A un juzgado superior, si pierde el juicio,
to require the Commonwealth to prove beyond a reasonable doubt
puede obligar a la fiscalía.
that you're guilty of the charges against you. You understand that by entering a plea today, you give up all those rights.
Si hoy se declara culpable, estará renunciando a todos aquellos derechos constitucionales.
Now, I may consider the Commonwealth's recommendation,
Consideran la recomendación del fiscal,
but I may apply any range of sentence provided by law.
pena que está dentro del ámbito legal.
In the event that I do not accept the recommendation
De que yo no acepto la recomendación del
and decide to
fiscal,
impose a harsher sentence,
imponer una pena más severa
you have the right to withdraw your plea of guilty and proceed to trial.
de culpable y proceder a un juicio.
What's the Commonwealth's recommendation?
¿Cuál es la recomendación del fiscal?
Upon a plea of guilty to failure to maintain insurance on a motor vehicle as required by KRS Chapter 304, the defendant shall pay a $500 fine and cost. Upon a plea of guilty to possession of a controlled substance first degree, methamphetamine, the defendant shall receive a sentence of 3 years. Upon a plea of guilty to tampering with physical evidence, the defendant shall receive a sentence of 5 years. The 3-year sentence and the 5-year sentence shall run concurrently for a total of 5 years. Defendant shall serve 90 days home incarceration with the balance pretrial diverted for 5 years. Supervised. The defendant shall provide proof of employment. The defendant shall receive credit for time served. The defendant shall obtain gainful employment or do a minimum of 30 hours per week until gainful employment is obtained. The defendant agrees to have any and all evidence in the above style case forfeited and destroyed. That is in a manner that is consistent with the laws of the Commonwealth and the holding agency.
Step back up here, please. Is that what you agreed to?
Yes.
Have you previously been diverted in the last 5 years?
Le habían dado una condena alternativa en los últimos 5 años. Yo nunca he tenido un.
Have you had a felony in the
I've
last?
never had any crime before.
Okay, no felonies in the last 10 years.
No ha tenido ningún delito mayor en los últimos 10 años. No.
Okay, you understand that if you complete the diversion program, the charges will be dismissed.
Entonces los cargos serán desechados totalmente de su
And
expediente.
you can have your record expunged, you will have no record.
Ha borrado el expediente penal para que no aparezca nada en su expediente. Yes.
Yeah. However, if you violate the diversion terms,
Con las condiciones,
you'll be called back in front of this court
le van a traer de nuevo aquí al juzgado
and I can revoke the pretrial diversion
a la condena alternativa.
and you would be a convicted felon.
Entonces sería un delincuente condenado.
In that situation,
En esta situación,
any future felony convictions could be enhanced as far as your penalty of service of a sentence.
se utilizaría para aumentar la pena.
You understand that?
Yes,
Okay.
but
No.
that won't happen.
I hope so.
Ojalá que no.
Knowing your constitutional rights, I've explained it's still your desire to proceed with your plea.
Porque los he explicado antes de que usted puede hacer su declaración.
Is that your signature on the document?
¿Firma en el documento? Yes.
Now, have you provided her a copy of that plea agreement
Copia de
in
ese
Spanish?
convenio en
Your Honor, I
español.
have not. I don't have a
En
copy.
español,
In
no
Spanish
tengo.
is,
Well, I want to make sure,
Yo quiero
does
que
she read,
ella-
does she
ella lo
read the
leyó.
English language?
¿Leer inglés?
No,
No.
no 100%.
Not 100%.
Me either.
Yo tampoco.
But what we need to do is you need to get someone to translate.
Necesita
To give her a
pedir a
copy of
alguien
it.
que traduzca el documento.
yes, sir.
Que
Now,
le entregue una copia.
with the translator, have they read through that with you completely?
La doctora leyó con ella el documento.
Sí,
Yes.
lo leyó con la
She
señora.
read it along with the
Sí,
lady
ella me
here.
leyó el-
They read it to me.
Okay,
Muy
well, I'll accept the plea
Acepto entonces su
and,
declaración de culpable.
and sign the pretrial diversion. What's the court cost?
La condena alternativa.
To what?
265.
Okay, we have court costs in amount of $265.
perdón, $265.
I'm gonna give you
Entonces,
some time to
ustedes,
pay
le
that.
voy a dar tiempo para pagarlo.
Pay it $30 a month.
Puede pagar $30 cada mes, ¿sí?
First payment starts 30 days from today,
Va a ser, doy hoy en 30 días.
and every 30 days until the 265 is
Desde el
paid.
primer pago, cada 30 días tiene que pagar $30 hasta que termine de pagar $265. Ok.
You know, you can meet with a probation
Usted
parole
puede
officer.
hablar con la gente
I would
de
still like for her to receive
la
a copy.
probatoria. Me
Yes, Your Honor,
gustaría
I
que
will see
ella
what I can
recibiera
do
una
to arrange
copia
that.
de
Your
su
Honor,
documento.
I did want to ask the court, I believe she
Yo
had a
quería
significant bond posted in this
preguntarle a su
case, that she's
señoría
hoping to
que
be
ella
released.
ya pagó
How
una
much bond
fianza
does she
bastante
have?
grande. Ella quiere saber si le pueden devolver el dinero.
Sí, son dos bonds. Uno de
There's
10,000 y uno de
there's two
2,500.
bonds.
How much? How much? 10,000 cash.
$10,000
Y 2,500.
What else? Yeah.
and 2,500.
12,500 total.
12,500 total.
Sí.
Yes.
Okay, well, I'll order the bond release, but we'll hold the court cost out of the bond.
Voy a mandar que le entreguen la
Was the
fianza,
bond her
pero
money?
voy
Is
a
it in her
pedir
name?
que el dinero de las tasas judiciales lo saquen de ahí. ¿Este dinero de la fianza era su dinero a nombre suyo?
Sí, es dinero porque se pagó para mi fianza.
Yes, it's money that was paid for me to be out on bond.
Was somebody
Pero
else's,
otra persona lo
somebody
pagó.
else's name?
Sí, es
¿Ella
dinero,
está a
sí.
nombre de otra persona?
Está a nombre de, lo prestó el patrón que la persona que a mi esposo.
The jailer says
My
it's in her,
boss is, my husband's boss is the one who loaned us the
the
money.
jail says it's in her name.
Lo ponen
Huh?
bajo su
It's not in her
nombre
name.
Sí.
cuando lo pagan.
So it can be
I don't
released.
know about that or not.
Yeah, whose name is it in?
Abajo de nombre de quién es la cosa.
Nicholas?
Ah, porque, sí,
Nicolás.
porque él pagó, él fue el que la fue a pagar para que yo saliera.
He's the person that came and paid it so that I could get out.
Okay, well, I'll release that bond to him,
Entregarle el dinero a él.
Ujú.
and then you can pay $30 a month.
Esos pagos de $30 mensuales.
Los 10,000 son de él, los 2,500 son míos.
The $10,000 belongs to him. The $2,500 is my money.
Okay,
¿Está bien?
Siento la acumulación.
it's an
I'm sorry to make it
evolving fact
confusing.
statement here, so.
Siento.
10,000 be returned to him, your fine will be deducted from the 2,500.
De los 2,500 le
I mean, court
vamos a
costs,
quitar
rather.
las tasas judiciales de 265 y el resto se lo regresamos a usted, ¿sí?
Sí. Ok.
Okay.
Okay,
Muchas gracias.
You'll need
Thank
to
you
meet-
very much.
Yeah, you'll need to meet with a probation parole officer. Who,
la
will you
probatoria.
have a translator available when she meets with you?
We do,
we've got a hotline. Sí, tenemos una
When do you want her at
que
the
podemos
probation parole
llamar. ¿Cuándo
office?
quiere que ella se presente en su oficina?
I need to see her about 12:30.
Necesito verla hoy como a las
Today?
12:30.
Be downstairs at 12:30 today.
Juzgado en el primer piso. a
To
las
meet with the
12:30.
probation parole
Necesita
office.
reunirse con el señor.
Voy a,
They'll get a translator on the line with you.
Van a tener una línea con intérprete para.
ok.
Okay, thank you.
Thank you, Your Honor.
You have anything for me to sign or anything?
Thank you so much.
Thank you very much, yes. Commonwealth versus Evelyn Shirley. Commonwealth versus Evelyn Shirley, 24 CR 0011. Are you Evelyn Shirley?
Yes.
Born in 1959.
Yes.
Last four digits, social security number 4698.
Yeah.
You're here today for sentencing. Have you had an opportunity to look at the pre-sentence investigation report done by probation parole?
Yes.
Your Honor, we've agreed to continue this a month or so. We're having some issues on some
Mr.
documents.
Stockton, you want to come around and get involved in this?
I will, Your Honor. And so we've agreed to continue it 1 month or until November, whatever's more convenient to the court, please.
There's been a request made and I need to get some advice from the Attorney General's office on the matter. And,
Schedule it for October the 8th.
Yes, sir. At 9 a.m.
or as soon thereafter as counsel may be heard.
Thank you, sir.
Yeah.
We can have that later.
Jeffrey Slay. Commonwealth versus Jeffrey Slay, 21 CR 0071, 21 CR 0072. Are you Jeffrey Slay?
Yes, sir.
Were you born in 1978?
Yes, sir.
Last four digits, social security number 8029.
Yes, sir.
Have you had an opportunity to look at your pre-sentence investigation report done by probation parole?
Yes, sir.
You had 5 years pretrial diverted for 5 years, and the diversion was voided on 8/15/2024. Do you have anything you'd like to say before I sentence him?
Yes, Your Honor. I had communicated with Mr. Stockton and we had requested for Mr. Slay to be assessed to see if he was eligible for the drug court program. He was found to be eligible and acceptable to the program, so we are asking for the court to give him the opportunity to do that rather than sentencing him to serve.
I will agree that he's health issues if the court wants to go along with that. Otherwise, he'd have
Has
to
he
wait.
been assessed yet?
Yes,
When can he be oriented?
that'd be up to Mr. Graves, but he's ready to be oriented. I don't know if we could find out. Somebody calls.
They usually do it on the end of the week. I'll find out.
If he's been voted in and he gets the orientation, I'll let him out on the morning of the orientation. We'll pass over this revocation. Well, I
Well,
mean,
you could sentence him and probate him in the drug court if you want to. I think that'd be the appropriate thing to do.
well, I think we gotta pass over it though to see if I can if I sentence him today and don't probate him today, then he's in and he'll have to wait
Well, he's
for.
been voted in. It's just a matter of the orientation.
I know he's been voted out. Well, only thing I'm saying, like I said, you know, if I go ahead and sentence him
Yeah.
and don't probate him today,
I see, then he would be in state custody.
he would be in state custody and I'd have to shock probate him then. But I don't know whether I'm gonna probate him unless he goes through orientation. But I'll go ahead and do it. I'll probate him. And then.
If
let
it
him
falls
know.
through, I'll be filing a motion for revocation.
Okay,
Yeah. See how complicated you make it.
Your Honor, if I'm clear, are you
I'm
holding
probating
him?
him. Well, here's the thing about it. No, actually, his pretrial diversion, I'm sentencing him today for 5 years and probating him. Okay. Subject to him being involved in drug court. It's been approved to get oriented. Okay,
And we make that a condition of his probation that he enter and complete the special.
Right.
program.
right. Aaron Southworth. Commonwealth of Kentucky versus Aaron Southworth for sentencing. Are you Aaron Southworth?
Yes, sir.
You born in 1992?
Sir.
Last four digits, social security number 7202.
Sir.
You're here on 22 CR 0072, 24 CR 0040 for sentencing. Do you understand that?
Yes, sir.
We had an opportunity to look at the precinct's investigation for probation and parole.
Yes.
Is it substantially correct?
Yes, sir.
Upon plea of guilty to second degree burglary, you shall receive 6 years. When it stipulates revocation on 22 CR 0072, thus the 6-year term shall run concurrently with 22 CR 72 and shall concurrently with Howland indictment 22 CR 0071 from Allen Circuit Court. Pay restitution amount of $2,750 plus clerk's fee regarding the missing NFV contender muzzle loader by Thompson Center and cost to reimburse remaining guns at a monthly payment of $150, the first payment being due to the clerk's office within 60 days of release from incarceration, and shall in addition to that pay the clerk's fee on the various reimbursements. Okay. Thank you.
Yeah.
Excellent.
David Teachout.
Mr. Southworth.
Yes, waiving the courthouse signature, Southwood. Commonwealth versus David Teachout, 21 CR 0095 for sentencing. Are you David Teachout?
Yes, Your Honor.
What's your year of birth?
3/6/1983,
Last four digits of your social security number.
0623.
You had a pretrial diversion which was voided on 8/15/2024. 3 years. Is there any reason this gentleman should not be sentenced?
Judge, the defense would like to make a motion for probation, with regard to his sentencing.
Well, here's what I'm gonna do. I'll consider a shot probation when it comes time.
Yes, Your Honor.
I'm gonna go ahead and sentence him to just 3 years, then you get together good reasons. After he gets this time in, why he should be given a chance, and I'll take a look at it then, okay?
Yes, Your Honor.
Terry Welsh. Commonwealth versus Terry Welsh, 20 CR 0037, a motion for shock probation. What do you have?
We actually had the hearing on this last month. You had asked us to figure out where Mr. Welch was going to be living and whether or not he could get a job once released. He has told me that if he is released onto shock probation, he would be residing at 316 WM Reeser Road in Moss, Tennessee. He believes that he can very quickly have his old job back at State Line Lumber. He said that he worked there for a couple of years prior to incarceration, 45 hours a week, and he assures the court that if released, he will begin to promptly make payments towards his child support.
Can we get him transferred down there?
That's a good question.
Your Honor, Benz, we've done it once and the issues that we had, I don't know if they'll take it. We should try it, but I.
Well, I want to see if if they'll take him again, and if they'll take him again, I'll consider doing that. Okay, so we'll hold an abeyance
We'll
till,
need to, and he'd have to almost been a resident down there and have a residence before they'll leave the city. So you'll need to get that information to Mr. Collins.
a resident certain that they can verify and go out and see if it's appropriate. You get a statement about having your job back. Is there anything else you need besides that?
That should be it. We'll get in contact with them and see.
Okay, we'll see if we can get that done.
Thank you, Your Honor. Would you like for us to refile or would you like to put it on for review?
I'm gonna hold it in abeyance.
Yep.
That way, so on, but, I don't know. Eric White. Commonwealth versus Eric White, 24 CR 0019. Are you Eric White? Born in 1985.
Yes, sir.
Last four digits, social security number 8918. We're here for a pretrial conference. What's
Did
it?
he- And we've had an issue with social security number. Did he answer in the affirmative? That is his last four digits?
8918.
Yes.
Yes, sir.
Okay.
What do you got?
Well, we
You
made an
come
offer.
around,
We've made an offer. It's been rejected. We need a trial date and
scoot over here, scoot you to the left here.
I will advise defense. There's a PS presented this morning.
What is the charge here?
Wanting endangerment and fleeing favor.
And your PFO on him today?
Yeah,
What-
because
what-
they're Tennessee charges. I mean, the basis of the PFO was from Tennessee. I had to get the judge.
And Your Honor, Mr. Stockton had let me know yesterday that he thought that this might be something that they were pursuing today. There is outstanding discovery on this case, namely the body cam that I had asked
Is there
about.
or not? Did you find out what you found out?
What was the offer you made?
It was 3 years to start. It counted 2 years, 1 day in the United States, not 3 years.
At what percent was the 30 years? I thought it was.
And if he gets PFO, it could be twice that, is that right?
Well, it enhanced it from a possible 10-year sentence to a 20-year sentence.
Judge, can I have a minute to
I
speak to
think you
Mr.
need
White,
to talk
please?
to him about it,
Yeah, thank you.
you know. Dakota Williams.
You feel one or two?
We're charging him with a woman, I think. No,
He doing pay bottle. No, he had told two. It's a two.
Okay.
Commonwealth Kentucky versus Dakota Williams. Are you Dakota Williams?
Sir.
Born in 2003.
Sir.
Last four digits, social security number 4744.
Yes, sir.
You're here on 22 CR 0018, 22 CR 0019, 22 CR 0021 for shock probation. What does the Commonwealth have to say? You want to come around?
Your Honor, he was revoked. We thought there was going to be a new felony case on the possession, but probation parole couldn't find anybody to assist on the lab, and I couldn't, so get it sent to the lab, so there will not be a new felony. And if the court wants to send him to a long-term treatment, which they've arranged, I will go along with it, but if not, that's where we are. That's based on the fact that there will not be a new felony on the possession.
So you'll go along with shock probation subject to him completing a long-term
At least 180 days.
180 days in a source or a place you can't leave without informants. If you leave, drop out of the program, you come down to the Barron County Jail and turn yourself in.
Mr. Williams.
Your Honor, I got a doctor's appointment today, this evening, over my leg. Is there any way that you can give me a furlough today to go over and get taken care of? It's at Dr. Michael Carter's office. I've already had the paperwork sent into their office and.
Okay, and you're in the Barron County, what does the Barron County Jail say about something like that?
Usually I'm responsible.
Do what?
Usually I am
Judge,
responsible.
He's a state inmate, we can't do it for long. This is a shock probation.
This is a probation revocation.
So you go along with shock probation.
Well, that's what's on the sheet. I didn't.
Shock probation revocation is what it says.
That's what we got.
Right.
You're, he's currently on shock probation.
Yes.
So I'm not gonna,
Basically, rather than revoke.
not gonna revoke him,
That's correct.
not gonna revoke him.
I need to order one.
So what I'm gonna do is,
It's correct on your sheet. I just got.
what time's your appointment out here?
3:30, Your Honor. I believe that I had emailed a copy of it.
Well, the problem is I don't know if I'll let him go out here to the doctor's appointment where they'll take him back at the jail over there. Now, will they?
Yes.
Okay. Then I will just type up a furlough situation and say he's to be furloughed and to be held in the jail till we find a long-term treatment center. Okay?
Sure.
And then we'll get that with him if you got somebody that can take you to the doctor's situation.
Grandma,
Where is she here?
she's not here, but she had Freeman to come here.
Okay.
See if it was available to happen.
Okay, well, that can happen. So we'll just try to get you some paperwork as soon as you finish with that doctor's appointment.
I'm straight back.
Well, you can go through McDonald's if you want to, but other than that, go over there, No.
Appreciate it.
Okay. Now it's 10:04 and we need to go to Christian County Detention Center because we've got them scheduled at 10. Christian County Detention Center, are you on the line? Okay, can somebody get a hold of Christian County Detention Center for us? Then we got Roder on the line. Is Roder on the line?
These are mine.
Roder? Neither one of those, they both called and they're not on the line. I'm gonna go to Barron County. No, they're not till 10:30, excuse me. Thought they were wrong. So we got 25 minutes to go on that. So let's go back to out of custody then. James Bristow. Mr. Bristow, if you just have a seat there on the front row where your attorney stepped out. Isabella Costado. What?
We're coming back to her this afternoon.
Okay. And that was Miss McCauley's case. Ricky Emberton.
He's been on one judge and I think he just stepped out.
Could you check out there to see if Mr. Ricky Emberton is out there? Moving right along here.
Yeah, he's able to.
They told me you were getting more difficult as you got older here, and I'm going to blame you. But I want to warn you that Mr. Hunley's been recharged and he's ready for you.
Yeah, I've noticed that, Judge.
He's like an energizer bunny now.
Yeah, my battery's about run. I believe I had some alkalines or something.
Noah Freeman. There he comes. Wait a second, Mr. Freeman. You have a seat there. We'll call you. Ricky Emberton. Commonwealth versus Ricky Emberton, 24 CR 0071. Are you Ricky Emberton?
Yes, sir.
You born in 1963? Last four digits of social security number 0973.
Yes, sir.
Here on a pretrial conference, what does the Commonwealth have to say? You gonna come around, Mr.
We need a
Clerk?
trial date, John.
What's the charge?
Wanting endangerment.
You made an offer.
Yeah. I have.
What did you offer?
I can't remember, but I never got a counter offer, so. I didn't see any point making it up.
Well, Judge, we'd be glad to make a counter offer, but
Okay, make one.
we'll take a trial date, Judge.
What is the charge gonna be tried?
Wanting endangerment,
Give me a little-
depending upon how far you set the trial date, they may be a misdemeanor, have you,
On the what?
or the horse. So. No, Mr. Amber is alleged to have tried to run over a man on a horse.
On a horse, okay.
Yes.
Got it.
Now, I won't leave the horse out. He has rights too.
If they do that, Judge, we'd like the right to confront the horse.
We bring him in.
Usually you're dealing with the other end of the horse, aren't you?
Usually I am the other. End, it seems like.
Okay, let's see what we have here. How far out, Mr. Stockton, do you need this to be?
Whenever, Judge, you want to say it's fine. I don't think there's any issue.
And Judge, just for the record, we've not received any video, any medical records, any photographs,
I don't
anything,
think there was any injuries.
no body cam. So as long as that's, if there is none, there is none, but we just want to put on.
There is, we'll give you at least 24 hours notice.
I appreciate it.
Mr. Reed, not kind of.
How about November the 8th?
Judge, I've got a jury trial set on the 8th. I don't know for sure if it'll go or not. Over in Judge Alexander's court.
Well, let's do it on the 15th then. Okay,
That's fine with me. Well.
I think we'll need to have the pretty road.
okay, 15th.
Thank you, Judge.
Okay. Noah Freeman. Commonwealth versus Noah Freeman. 22 CR 0034. And 24 CR 0062. Good morning. Are you Noah Freeman?
Yes, sir.
You born in 1981?
Yes, sir.
Last four digits, social security number 1932.
That's correct.
We're here on pretrial diversion, revocation, and a pretrial conference. What's the Commonwealth at?
Your Honor, this is a case where I have furnished the last bit of discovery. I need to have one more pretrial negotiation, one more pretrial.
What is the negotiation date?
It'd be,
Judge,
no,
I'll be,
October the 4th at 9.
I'll be gone in October. Not,
Mr. Bell, that'd be fine. Mr. Freeman will have to be.
I just, I'll be on vacation, fall break.
You won't be here the 8th either week.
No, I'll be gone that whole week. The 5th through the 12th.
Well, I think what I need to do is, on all of these cases, all the co-defendants, I need a pretrial in November so I can set the trial. And they all get.
What is the
Here in October either.
What's the November date of your negotiation?
November would be the first Friday at 9 o'clock.
November the 8th.
November 1st. You'll be here at 9 a.m. for negotiations on November 1st, and your next court date is November 14th.
If we just knock out all the co-defendants while we're at it.
Okay, who you call them? We'll call them up here.
Pettigo.
Okay, let's Pettigo, Commonwealth versus Pettigo. Caleb Pettigo, and who's next?
Jody Murphy,
Jody Murphy.
Joby Grace.
Murphy, I think was continued.
Yeah, he was continued to October, Bruce Brown's request. And Dalton Birdwell's in custody.
Damien Hurt.
Damien Hurt.
Okay,
Yeah. We'll get him next month.
okay, let's go down through this so I can identify you. You let your client step behind that. Would you identify yourself, ma'am?
Michaela Pettigo.
Michaela Pettigo. You're to be back here on November 1st for negotiation at 9 a.m.
Your Honor, if I may, I apologize. I'm Xanda Myers. I represent Michaela Pettigo. I have a final sentencing in a dare circuit beginning at 8:30. I don't know that I
I
can be
can help you
here
get
right
that,
at 9.
I can help you get that rescheduled.
Is that on the 1st or the 15th?
That's November 1st.
I have a good relationship with the circuit judge there.
Well, it's a different circuit judge. It's a conflict circuit judge that is in. It's Judge Spalding.
I have a good relationship with him too. As a matter of fact,
That's just the negotiation days.
So she can contact me at her convenience.
well, they want everybody there.
Yeah, I want everybody to give them one final opportunity if this case is not settled and.
Well, I understand. That's the reason why we got to have her here and all these other people going to be here at 9. If she's not here at 9, it won't work.
I agree with that.
How late will you be here today? Or
Depends
that
on how
day?
cooperative you are, I guess, and how
I'll be here
cooperative he
whatever time
is.
you need me to be here.
So I begin at 8:30 and I can request that judge call my case first at 8:30 on November 1st. And then I'll just have basically travel time to get here,
I'll be here.
which I'm thinking would put me here by 10 if everyone else could be here at
Never
that
leave
time.
before 10 on negotiation day.
Well, these other people will still be here, so you're gonna tell all them to come at 10?
Well, if they don't resolve their case, I can deal with them and we can go on.
Okay, well, I'm,
Your Honor, I've got adjudication at 9 a.m. in Hart County on November 1st.
I just think we're all too busy to handle this case
I
right
think
here.
so.
So,
Now, I could be in touch with Commonwealth Attorney before that and after that by phone anytime. So I think we could probably work it out and keep the November dates, but at that specific time, I can't be there. I can be there a couple hours, maybe 12 o'clock, 1 o'clock in the afternoon.
okay, we'll be here that day. You tell your client what to be here, what time to be here.
Yes, sir.
Okay, now you're Michaela Pettigo.
Sir.
Okay, so you're gonna be here.
I can be here as soon as I finish in
That's
Adair
fine. So
County.
you're gonna be
on the
here and you'll
1st.
work out the time with the Commonwealth.
My concern is November 14th, if that's the follow-up pretrial conference before you, Your Honor. I'm scheduled to be in trial in Butler County before Judge Coleman. And that is an organized syndicate that includes 3 other defense attorneys too, unfortunately.
Well, you just need, on November 14th, you just need to provide us with your calendar and what days you're available. That'd
Would it
all
be
right.
permissible for me to have my investigator come down? He
You
obviously
get on
can't.
Zoom, why don't you just take a break and get on Zoom? They'll let you step out of the courtroom.
Judge Coleman will permit that. I
I'll
don't
call and
mind.
personally ask Judge Coleman. to
I
do that.
appreciate that, Your Honor.
I'm gonna have to call in a lot of favors to get this case over with, I can say that, but I'll call the judge and ask him if he'll let you step out and be Zoomed, okay?
Understood. Thank you.
Okay, now, you may go and talk to your attorney, okay? Now you come up, ma'am, and identify yourself. We finished with him, we got a date set for him, what's the date? You're right, okay. Okay, that's, what's your name, ma'am?
Jody Murphy.
I don't see you on the docket. What's the deal here? I don't see her on the docket. Who's your attorney?
I don't see him.
Bruce Brown.
It was continued. There
It
was
was
an order.
continued by agreed order to November. That's the reason we're getting the November date.
Okay, you need to be here on November 1st with your attorney at 9 a.m. And then your next court date is November 14th. Your attorney had an agreed order to continue your case till then, okay? Can you write those? You want to write those down? I hate to impose on you. Here you go. Let her have one of these little state yellow sheets there.
Yes, sir.
Write those 2 down. Okay, now you can step aside there. Sir, what's your name?
Grace.
Joby Grace, 24 CR 0061.
And Your Honor, Lee Davis for Mr. Grace.
So you're gonna be here sometime on November 1st.
Yes, sir.
And then on November the 14th, are you
Yes,
gonna be able to be here? You'll be
Yes,
there
sir.
both days. So
Yes, sir.
you coordinate with your attorney what time to be here on November 1st. Okay, so you want to sit around all morning.
Yes, sir.
Okay,
Thank you. May we be excused, sir?
absolutely.
Thank you.
Now, you come around and identify yourself.
Damien Hurt.
Damien Hurt, 24 CR 0066. You've got an arraignment to do here. You have the right to remain silent. You're here with counsel. If you have any questions, you step away from the podium so you can talk to him, okay? You are Damien Hurt. You're born 1979. The last 4 digits of your social security number 2714.
Yes, sir.
The grand jury of Monroe County has returned a 4-count indictment charging you with being a persistent felony offender in the 2nd degree. You understand what those charges are? Okay. Counselor, you acknowledge the identity of your client, receive the indictment, wait formal reading and arraignment, enter plea not guilty, reserving all pretrial motions.
I do.
I'll consider the bond, keep the bond in place that you're on now, so you can leave here today. You be back here on November 1st at 9 a.m. for negotiations, and November 14th for your next court date. If we don't settle, we'll set you a speedy trial, okay?
Thank you, Judge.
Okay. Okay, Jeremiah Harden. Active warrant, Mr. Stockton.
We'll take care of it, John.
Emanuel Howard. Commonwealth versus Emanuel Howard, 24 CR 0050. Good morning, Mr. Howard. You born in 1985? Last 4 digits, social security number 7462.
Sir.
We're on a pretrial conference. What does the Commonwealth have in this case?
Felony plea, Your Honor.
A motion's been tendered, sir, that says you wish to enter a plea today. Is that correct?
Sir.
Currently under the influence of drugs or alcohol? Is this plea freely and voluntarily given?
So.
Are you the same person named in indictment number
So.
24 CR 0050? Is your judgment impaired today in any way? Is your judgment impaired? You know what's going on? You're not confused or anything? Okay. Have you discussed this matter with your attorney and are you satisfied with her advice? Have you viewed the evidence Commonwealth has against you, believe you're fully informed about your case? You don't have to enter a guilty plea today. You have certain rights under the Kentucky United States Constitution. Before I can accept the plea, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything. Right to speedy trial by jury, right to be represented by counsel at your jury trial. Right to confront and cross-examine all witnesses called to testify against you. Right to produce evidence. Right to call witnesses in favor. Right to appeal this matter to higher court if you lose. Right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charge against you. Understand that by entering a plea of guilty, you give up those rights. You understand that?
Sir.
Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided below. I don't have to accept the recommendations. Prior to accepting your recommendations, I'll have a pre-sentence investigation report done by probation and parole. In the event that I decide to impose a harsher sentence than you've agreed to, I will allow you to withdraw your plea and go to trial. You understand that? You'll step to your left, sir. Okay. Ms. Gordon Anderson.
Yes, Your Honor. Upon a plea of guilty to trafficking in a controlled substance, first degree, second offense, the defendant shall receive a sentence of 8 years to serve. The defendant shall receive credit for time served. The Commonwealth opposes probation and shock probation. The defendant agrees to have any and all evidence in the above styled case forfeited and destroyed in a manner that is consistent with the laws of the Commonwealth and the holding agency.
Is that what you agreed to, Mr. Howard? Sir. And you agreed to that because you did commit the acts that you're charged with, is that right?
Yes, sir.
Okay. Knowing your constitutional rights, as I've explained, is still your desire to allow me to fix the punishment. You understand that after any of this plea, any future convictions that you have, this could be used to make PFOs out of them. You understand that?
Sir.
It would enhance your sentence. Okay, is that your signature on the document?
Yes, sir.
Okay, I'll accept the agreement, order pre-sentence investigation report to be done by Department of Corrections and schedule your sentencing on October the 8th. You're in the custody of the jailer. He's in your custody, Mr. Jailer. Thank you. Shannon Keith. Shannon Keith. Commonwealth versus Shannon Keith. Shannon Keith is not appeared.
Your Honor, it is my understanding that Mr. Keith was having to arrange transportation and has issues with that, so that he would be here in 45 minutes.
Well, I'll pass him to the end of the docket. If he's not here when I finish calling the docket, we'll issue.
Thank you, Your Honor.
Kri Marley. Kri Marley. Commonwealth of Kentucky versus Kri Marley, 24 CR 0043. Are you Kri Marley? Born in 1977.
Yes, sir.
Last four digits of your social security number. 3162, is that
Yes, sir.
correct? This is a pretrial conference. What do we have here?
We've made an offer, Your Honor.
Your Honor, at this point in time, Ms. Marley has not expressed a desire to accept that offer.
Okay, let's set a trial rate. What's the charge?
It's a possession.
What did you offer?
Well, I offered 3 years probate for 5 or 60 days in jail, but I was gonna change that to home incarceration. I never got any counter offers, so.
I have the first year where I got arrested, where I went to
Well,
all the
you don't need to
IOP
be,
and all that, and she wanted-
hey,
Yes, sir.
don't be saying anything,
Yes, sir.
because you might incriminate yourself,
Yes, sir.
okay?
Your Honor, me and Ms. Brown both have late next week available if the court wants to schedule it for then, and the Commonwealth is available
What are you saying?
for the trial date, Your Honor.
Yes, set a trial rate, okay.
I guess she's requesting a speedy trial from the family.
You want to try it next week, is what you're telling me?
We have that available, Your Honor. Both mine and Ms. Brown's schedules are very full through the end of the year, and we don't have very many dates
Can you be
available.
ready on September 20th, right?
The 20th.
week from tomorrow.
Well, since I sent out an email for the PDV meeting about having a meeting, I'd like to attend that.
Well, so you're not available on the 20th.
No, I'm
It's
not.
okay, it's all right.
So I'm asking.
I've got October 1st and 2nd marked down for hearings. I don't know what that means.
That's when we try to schedule the domestic hearings and nobody can practice it.
We are not available on October 1st and 2nd, you're at trial there.
I think I need another lawyer. Please.
You don't get to choose your lawyers. You get a public defender and they assign somebody. I don't think I would want to be your lawyer. If you don't comply, step away from there and talk to them. Don't be saying anything else on the record because you incriminate yourself. Step away and talk to them for a second. Absolutely. Diego Morales. Have we called Diego Morales? This is one John Cottle.
He was on Zoom in his court earlier. I turned his video off and I don't know that he's rejoined.
Those days. We're trying to find your lawyer, Mr. Morales. John Cottle. John Cottle, are you on there? Yeah, you can have a seat back there and we'll call your case back up. Robles. How you say your client's first name?
Fatima.
Fatima Robles. Are you Fatina Robles? Born in 1996?
Yes, sir.
Last four digits, social security number 6935. Okay, what do we have? A pretrial conference? Come
Your Honor,
around.
we have the
Come
test
around,
result
come around,
back
come around. Y'all move to the left.
on the fingerprints, and they've sent the weapons to the firearms section. And this has just happened within the last 2 days, so we've got to get with the firearms section and see how long that's going to be. So we'll know then when we'll have the final test, and we'll be ready to set it for trial for you.
You know, go ahead and set out to November 14th.
That'd be fine with me.
Let's have a negotiation day on November 1st.
Okay.
And the next court date on November 14th. If you have not provided discovery in for sufficient time for
We should know
counsel.
something by then to tell Mr. Garrett on the firearms.
So you don't have to be there on November 1st if you're not ready to negotiate. If y'all,
That'd be
so
fine.
you should do an agreed order continuing it to November 14th. Garrett Rush. Mr. Bailiff, will you hand that over to the, they can incarcerate Mr. Howard. Thank you so much.
Thank you.
Commonwealth versus Garrett Rush. DPA represents Mr. Rush. Mr. Rush, just have a seat on the front row there, just for secretary. Jonathan Russell. Jonathan Russell. Commonwealth versus Jonathan Russell, 24 CR 0018. This is Mr. Russell, were you born in 1978?
Yes, Your Honor.
The last four digits of your social security number is 7142.
Yes, Your Honor.
Okay, we have arraignment here. So you're present with counsel. You have a right to remain silent. The grand jury of Monroe County, if you're turned in indictment, charge you with tampering with physical evidence. You understand that charge?
Yes, sir.
Counselor, you acknowledge the identity of your client, receive indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, sir.
Okay. Okay, now you have, the Commonwealth have a motion or?
I believe we do.
Okay, you want to move over to the left here? You'll move to the left. Okay, Mr. Hunley, what do you have here?
Judge, I don't have the motion in front of me, but this case, Mr. Russell's case is scheduled for trial on the 17th, which would be next week.
Yeah.
We learned last week that and he's charged with an assortment of charges, one being an assault first from a shooting, another being a violation of an EPO order out of Allen County, and thirdly, with tampering with physical evidence. The victim in the shooting is hospitalized now and has been since August at Vanderbilt University with a serious condition. The doctors have informed us that she won't be available. They're holding her in complete bed rest until a child can be delivered sometime in the early part of October. So she's not available for the trial of assault one.
Okay.
I informed Mr. Bell of that. I first suggested that we might get a continuance of this case, but he was non-committal on that. Then we had our meeting Friday on the negotiation day, and he was further non-committal on it. I never heard anything further from him, so I filed a motion to sever these cases. I can try the case on the EPO violation and the tampering without the presence of this lady. I can't try the assault without her presence. So my motion was to sever those latter two charges from the assault one.
Judge, first of all, we would object to the severance. We were just here at the last pretrial day and they had filed a motion to join these together. And then we come back today, now they want them separated back, so I'm a little confused.
Well, the confusion appears to be is the health of the witness.
As far as the.
Is that right, Mr. Hunley?
That is correct.
It's no confusion. They got a witness.
As far as the request for a continuance, Judge, he says non-committal. What I said was I hadn't talked to my client and I couldn't.
You don't
agree that.
object, continuance?
I don't, Judge. And the reason I didn't contact him was because I had.
Well, here's my problem. We looked at the file when this motion was sent. We saw where it had been joined. It appears to me is the violation of the protective order involving the same lady that's going to be in the hospital?
Yes.
Yes.
Okay. Well, it appears to me that if you got him in for a violation of EPO or something, that there might be a confrontation problem since she's not available and she was the one that was protected by it.
Well, and also the process in the Commonwealth of Kentucky was a victim.
That's true.
Because the EPO had certain specific requirements.
I understand.
The evidence will show that they were violated. Now, if they are, that's a misdemeanor.
Yeah. When is this baby scheduled for birth?
Informed October.
Yeah, it just says October 20th.
They don't know when, Judge.
Well, that's something we can all be certain of is they never know when.
So they're waiting for the child to develop to the point that a cesarean can be done, is what I'm informed.
You said it was in November?
October, that's what the doctor. Yes.
Well, let's go into November.
Is there any way we could go to the first of the year on this, Judge?
Why?
Oh, that's the reason. I would assume that there could be complications that would lend to a situation where the child and or the mother or
Well, let's
both.
schedule something in December then, and we'll know more about it in December. And this will be an ironclad thing. You got your calendar with you in December?
I'm available, Jeff.
We set one for December 10th a while ago.
I'm available for the 10th.
Well, we already set one a while ago for the 10th.
What did we set for the 10th?
Yeah.
Yeah, I know.
This is probably a 2-day trial, would you think?
At least, yes, sir. I would agree. As long as there's no more indictments.
17th and 18th.
Judge, I'm available the 17th. Is there any way we could do the 16th and the 17th?
Or are you gonna be on the 18th?
Leaving town. I mean, I'm not gonna sit there and lie to you. It's something I could cancel, but I hate to. But if you tell me to, I guess I will.
Now, you're talking about December, is that correct?
Yes.
I might suggest if you get very close to the Christmas holidays, you'll have a hard time getting a jury in to agree.
Just have to call me Scrooge. Oh, I know. We'll get them here. 16th and 17th.
You've been called worse than that, haven't you, Judge?
And very recently. By you, actually.
I wouldn't think that, but.
Before you couldn't.
Well, I was really thinking that an earlier part in December would be more likely.
Okay, let me take a look. So the 2-day thing's what gets us. You have the file on this. What's the number on this? There was there's two different, what I was saying.
There's just one, 24 CR 18.
See, I was looking 23 CR 001 too.
Oh, I want to take that.
Okay,
There's both.
okay, thank you.
The last indictment, just a supplemental indictment,
Two tampering charges, I believe.
same tampering charges referenced in another. The new indictment was cleaning up some of the wording and right.
That'll need to be cleared up in the file, because as of right now, there's 15 different charges under that indictment.
That's why,
No, we're just merely stating facts.
okay.
He accused us of ganging up on Flurry, and I said, no, we're just stating facts.
What about the one that we have scheduled for the 10th? Maybe we could move it to the 17th and put this one on the 10th. See what I'm saying?
My schedule is open.
Who's the attorney?
I am.
Both of them are yours?
Yes, sir.
Let's switch those,
That's
okay?
fine. That ain't no problem.
Okay,
So we're gonna do Russell on 10th.
the 10th and 11th.
Well, the reason I went to the 10th because I had the trials on the 11th.
9th and 10th. 9th and 10th, okay.
Yes, sir.
Russell on,
Yes, sir.
and then we'll move the other case. To the 17th, is that right?
Yes.
Another problem solved. Okay. Yeah. Gerald Ryan. Commonwealth of Kentucky versus Gerald Ryan. Twenty-four CR 00655. Are you Gerald Ryan? Okay, you born in 1957. Last four digits social security number 8954. Okay. You're here on a pretrial conference.
Your Honor, we've had some recent developments. The Commonwealth is still conducting an investigation, getting records from two different entities. We have November the 1st and November the 14th. And if we don't have a settlement on the 14th, we'll ask.
You'll be back here on November 1st for negotiation day and November 14th for your next court appearance. Okay?
Sure.
Yeah. Chad Shirley.
You said you weren't gonna be here in October.
Right, the 1st and 14th, it's all right.
Yeah.
Commonwealth versus Chad Shirley. Had to look up Mr. Shirley, still, let's see if it's still morning. Good morning. This is 24 CR 0029. Mr. Shirley, were you born in 1990?
Yes, sir.
Last four digits, social security number 4625.
Yes, sir.
Okay, we're here for a pretrial conference. What do you want to do in this?
We recently did furnish discoveries, I think the final discovery to Mr. Bell. So since he's not here in October, can we have the 1st and the 14th?
November the 1st, you'll be here at 9 a.m. for negotiations, and November 14th, you'll be here for a pretrial conference, either enter a plea or second trial, okay?
There's one more piece of discovery that we're waiting on.
What is that? You can go over and tell him if you don't want us.
I let them know this morning.
Okay, is it time sensitive? I mean, is it gonna take time to do that?
I mean, I'd like to have it.
Well, I know, what is it then?
It's a recording of Evelyn Shirley statement, a second interview.
Okay, that won't be a problem. We thought we furnished it already, but maybe
We got one.
maybe there's a technical issue or something, but we'll clear that.
Okay, that'll be fine. Okay. Sir, you want to come back up here? We kind of skipped over. You state your name, please.
Rush.
Yeah, Mr. Rush, you're here on 24 CR 0068. Were you born in 1982, Mr. Rush? Last four digits, social security number 5050. Mr. Bell, y'all are keying the mic, okay? We have a pretrial conference. What does the Commonwealth have in this case?
No.
We have a pretrial diversion, Your Honor.
A motion has been tendered, sir, Mr. Rush, that says you wish to enter a plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person that was named and identified in 24 CR 0068?
Yes, sir.
Is your judgment impaired today in any way? Have you discussed this matter with your attorney, and are you satisfied with her advice?
Yes, sir.
Have you reviewed the evidence Commonwealth has against you, and you believe you're fully informed about your case?
Yes, sir.
You understand that you don't have to enter a guilty plea today. You have certain rights in the Kentucky United States Constitution. I'm gonna go over those rights with you to make sure you understand them, and I'll ask you if you do. You have a right not to testify against yourself. No one can make you say anything. Right to speed trial by jury, right to be represented by counsel in jury trial, right to confront and cross-examine all witnesses called testify against you, right to produce evidence, or right to call witnesses in your favor, right to appeal this matter to higher court. If you lose, the right to require the Commonwealth to prove on a reasonable doubt you're guilty of the charge against you. You understand that entering this guilty plea today, you're giving up all those rights.
Yes, sir.
Now, I may consider the Commonwealth's recommendation, but I may apply any sentence provided by law. Shortly, you're going to listen to the recommendation. If I try to impose a harsher sentence than that, you have a right to withdraw your plea and proceed to trial. You understand? If you'll step to your left here, Miss Gordon Anderson.
Yes, Your Honor. Upon a plea of guilty to possession of a controlled substance, first degree methamphetamine, the defendant shall receive a sentence of 3 years, pretrial diverted for 5 years, supervised. The defendant shall be referred to the social service clinician and follow any and all recommendations. The defendant shall receive credit for time served, shall obtain gainful employment or do a minimum of 30 hours per week of gainful employment until gainful employment is obtained. And the defendant agrees to have any and all evidence in the above style case forfeited and destroyed in a manner that's consistent with the laws of the Commonwealth of Kentucky and the holding agency.
I've got a few questions I need. Have you previously been diverted in the last 5 years?
I'm sorry.
Have any felony convictions last 10 years? Or currently on probation?
I'm sorry.
You understand if you fully complete the diversion, charge will be dismissed pretrial diverted, you can have your record expunged. You understand that? You understand if you do not successfully complete diversion, you'll be brought back before the court. Court could schedule a hearing, and if I revoke your pretrial diversion, I order the pre-sentence investigation report to be done by probation parole. You'll be a convicted felon. That can be used against you in felonies in the future to enhance your sentence. You understand that?
Yes, sir.
Are you pleading guilty because you did commit the act charged in the indictment?
Yes, sir.
Okay. Are you doing so of your own free will?
Yes, sir.
Knowing your constitutional rights, still your desire to proceed with your plea and allow the court to fix your punishment. Set your signature on the document.
Yes.
Okay. Now, I'm gonna accept the agreement, sign the diversion, or what's the court cost in this thing? $215. I'll give you some time to pay that if you want to. You can pay it at $30 a month. The first payments that we do 30 days from today. Now, you'll need to meet with the probation and parole officer over there. He's not drug court eligible or anything?
No.
Let me look at it. Where's the file at?
Wasn't part of the agreement, right?
Oh, it was not.
Okay.
He had a minimal criminal history, is the reason I didn't recommend it.
All right. So are you currently employed?
Yes, I am.
Okay, and so this was drug, at least at this point, hadn't significantly interfered with you. Well, it's a good thing.
Yeah,
You
thank
know,
God.
there wasn't anything like this around when I was a young guy or that sort of thing. I never was much, I never even did any marijuana, but you know, I drank some when I was that age and things like that. So I don't know what sort of thing, but this stuff can ruin you.
Absolutely.
Almost has, hasn't it?
Yes.
Okay. Will you meet with the probation and parole officer over there? Did you have the agreement? Did you give the agreement up here? Okay. The agreements disappear sometime.
Still on the trial.
Christopher Stillwell. Christopher Stillwell. Commonwealth Kentucky versus Christopher Stillwell, 24 CR 0012. Are you Christopher Stillwell? You born in 1975. The last 4 digits, social security number 6497. You're here on a pretrial conference.
Yes, sir.
What does the Commonwealth have to say?
Well, last time I talked to Mr. Bell, I thought we was getting a trial date, but I don't know.
Judge, we negotiated a plea out on the negotiation day. I spoke to Mr. Stillwell. At that time, he didn't want to do it. He had called me thereafter and said that it might be something that he wants to do. Due to some illness that I had up until basically yesterday, I wasn't able to meet with him. I'd asked the court to allow us to have the first and 14th.
What was the offer?
It was trafficking. It's 14 grams of meth and I offered 10 years, serve 180 days, balanced probate for 5 years.
So he is strong.
We'll give him another negotiation day or?
Well, this case has drug around for a while. We've made accommodations for Mr. Stillwell, so Mr. Bell could go to post and examine evidence. I would like to get the plea entered maybe next week in Cumberland or something, or some other day, rather than
Tell you
wait
what,
2
you
months.
decide, but we'll bring you to Cumberland County next week, next Thursday.
Do you understand? I don't want to wait till November on this, Mr.
Yeah,
Bell.
that's what we're gonna do. We're gonna do Thursday. You have time, plenty of time to talk to your lawyer between now and next Thursday.
Judge, let me see what my calendar is next Thursday. That's the 19th. Yeah, well,
And if you get over there at 9 o'clock, we'll take you up first.
okay, Judge.
Okay, and I'll have my calendar with you, have your calendar with you. If we can't get a plea agreement, we'll set a trial. Okay,
That'll work.
okay, thank you very much. Benjamin Tooley. Commonwealth versus Benjamin Tooley, 24 CR 0020. Are you Benjamin Tooley?
Sir.
You born in 1987, last four digits social security number 2174. We're here on a pre-trial conference on 24 CR 0020. What does the Commonwealth have to say?
Your Honor, I think I don't mind passing this for a few months. We're waiting on Mr. Tooley's case to be tried in Howland. And,
What's going on with that case? That's what we said last time. We were-
yeah, well, because of the election, I don't think it's gonna be tried till next year. And then Mr. Bell said he'd like to have one more month on it.
He had made an offer to his judge, and I told him that I thought Mr. Tully would accept that offer as long as it wouldn't affect the situation over in Allen County. So I just asked him to let me talk to them and see where we're at on that. If we come back, we should have it resolved maybe by the
Let's say in
14th.
November.
November 1 and November 14. Okay,
Thank you,
need
Judge.
both those at 9 o'clock here, one for negotiation on November 1, November 14th is a trial date. Both of them conditions your bond. You understand that, Mr. Stewart?
Sir.
Okay. Okay, let me get this gentleman here ready first. You want to come back up around, sir? I almost forgot you, man. Come back up here and state your name again. We'll get
Eric White.
What number is he on the docket?
Eric White.
Is he custody?
Oh, okay, that's the reason I marked him off earlier. He was looking at it. Commonwealth versus Eric White, Eric White, 24 CR 0019. You are Eric White, you previously identified.
Yes, sir.
Born in 1985, last four digits, social security number 8918. You have a plea agreement now?
Yes, Your Honor.
Is it a felony plea agreement?
It is, Your
Okay.
Honor. It will be to serve.
Okay, a motion has been tendered, sir, that says you wish to enter plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
Yes, sir.
Is this plea freely and voluntarily given?
Yes,
Are
sir.
you the same person named in indictment number 24 CR 0019? Is your judgment impaired today in any way?
No, sir.
Okay, have you discussed this matter with your attorney and are you satisfied with her advice?
Yes, sir.
Have you reviewed the evidence the Commonwealth has against you and are you fully informed about your case?
Yes, sir.
You understand you do not have to enter a guilty plea. You have certain rights under the Kentucky and United States Constitution. Before I can accept the plea, I need to know that you understand those rights.
Yes, sir.
You have a right not to testify against yourself. No one can make you say anything. You have a right to speed trial by jury, right to be represented by counsel at your jury trial, right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, right to call witnesses in your favor, right to appeal this matter to higher court if you lose, right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charge against you. Understand that by any guilty plea, they give up all that's right. Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided below. I don't have to accept the recommendation. Prior to accepting the recommendation, I'll have a pre-sentence investigation report done by probation and parole. In the event I do not accept the recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. And what is the Commonwealth's recommendation?
Your Honor, Mr. White agrees to plead guilty to fleeing, evading first degree, wanton endangerment first degree, receive a sentence of 3 years on each charge to run concurrently for 3 years to serve. The Commonwealth opposes probation, shock probation. All evidence in this matter will be destroyed and pay court costs at discretion of the court.
Is that what you agreed to, sir?
Yes, sir.
Okay, are you pleading guilty because you did commit the acts charged in the indictment?
Yes, sir.
Okay. Now, are you doing so of your own free will?
Yes,
You know
sir.
your constitutional rights is to your desire to allow the court to proceed and fix your punishment when the range permitted by law. Is that your signature on the document?
Yes, sir.
You understand that any future convictions of felony could enhance the range of penalty and persistent felony offender law. Okay, now, did you say there was something in front of the grand jury today?
Yes, Your Honor, the PFO need to be dismissed if there's one at home.
Okay, well, what we'll do is that needs to be put on the plea agreement.
I can just an order dismissal, because I gave it the same case number.
Would that work if we didn't order dismissing?
It would, but it would appear to me that,
Oh, that's what it was.
Oh, they didn't present it, so we don't have to worry about it.
okay, good.
Yeah.
That's better. Okay. Okay, I'll accept the agreement order PSI and schedule sentencing on November the 14th. Yeah, October the 8th. I'm sorry. Everybody else was skipping over October. Okay, that'd be fine. Now, let me bring the grand jury out here before we have a few things to finish. Do you have anybody else back there? Okay. Let me have, if y'all will clear the grand jury area, and then we have just a few other cases, and then we'll be over to Glasgow here shortly. Bring the grand jury, please.
Judge, just a heads up that D niece that's showing up on the screen is prisoner Terry Strode over at Bluegrass Correctional Complex, I think it's called.
Okay, then we'll call that next after I finish with the grand jury here. That's for sentencing in 22 CR 0032, correct? Correct. All rise for the grand jury, please. Okay, everybody can be seated. Ladies and gentlemen, the jury, those seats remind me a little bit of Southwest Airlines. You just got it right up under your chin there, you know what I mean? So who's the foreperson?
I am, Your Honor.
Mr. Foreman, have you finished your work?
Yes, we
And
have.
9 or more of you agreed on those?
Yes.
Okay, Mr. Bailiff, will you retrieve that document? Y'all are keying the microphone. Y'all are keying the microphones. Okay, ladies and gentlemen, the jury, I'll inspect everything seems to be in order. Here, we will issue the appropriate documents. See that you found a couple of charges that was enough to proceed on. I will go ahead and, if these people are in custody, we'll probably do summons for them. If they're not in custody, we'll do arrest warrants for them and post the bond sufficient to assure their attendance, or if there's a protection issue to protect the public, okay? The next day that you're to be back is on October the 8th. And that's a change date. It was the 17th originally, and now it's going to be on October the 8th. Y'all got that? Unless you're called back for insurrection or something like that, who knows? So thank you very much. All rise for the grand jury. Oh, okay, everyone can be seated. Let's go to online to Terry Strode. Commonwealth first, Terry Strode. 22 CR 0032, Commonwealth of Kentucky versus Terry Strode. Mr. Strode, you need to turn your camera on.
They tried, it won't come on for some reason. It says video going, but it's not coming up.
No. Sure.
There we go. No.
Yeah, hit that little camera logo again. So,
It's on, it's just black. I can see it.
yeah, I don't know why it is.
No, I can't. He's got it turned on down here, it's just showing up black.
Yeah, it's pre-sentence investigation. Thank you. Mr. Strode, what are the last four digits of your social security number?
3139.
And your year of birth?
8472.
Your attorney, Stephen Poindexter, is on the line. Mr. Poindexter, you recognize Mr. Strode's voice, although we can't see him. You acknowledge that his identity?
I do, Your Honor.
Mr. Strode, if you had an opportunity to look at the pre-sentence investigation report done by probation and parole.
Yes, sir.
Is it substantially correct?
Yes.
Is there any reason, Mr. Poindexter, this gentleman should not be sentenced today?
No, Your Honor.
On a plea of guilty to possession of a handgun by a convicted felon, the defendant shall receive a sentence of 5 years. The 5 years shall run concurrently to the 20-year sentence received in case number, in this case, entered on September 15th, 2022. In conjunction with the plea, the parties to submit a degree order resolving all other issues in the case. Is that what the agreement was, Mr. Poindexter?
Yes, Your Honor.
Yeah. And the PFO.
Okay, so we'll enter a judgment to that effect. Okay?
Thank you, Your Honor. That's all I have. Can I be excused?
Yes, you may be excused too, Mr. I waive court cost. Waive court cost. Okay. Okay. Do we have a Shannon Keith here?
He'll never come up, but they might get it before. Well, thank you. They did. Thank you.
And that all. Commonwealth versus Shannon Keith. 20 CR 0038. Are you Shannon Keith?
Yes, sir.
Born in 1975?
Yes.
Last four digits social security number 0956.
Yes.
Your revocation, what's the Commonwealth have to say?
Your Honor, Mr. Keith is on probation for flagrant non-support. And he had been paying pretty good. He had some illness, didn't pay in June and July. He'd had at least 3 positive tests for alcohol. He refused treatment through probation and parole, and that's my understanding that, and I don't, that's.
So you willing to pass over if he'll work
I
out?
don't know if they've got some type of short-term treatment for alcohol use lined up. If not, I might want to proceed.
Probation and parole. Y'all have anything lined up for him, or are they gonna line it up?
Judge, we were going to do that. We are still working on that. I did indicate to Mr. Stockton that we might have something this morning, but we do not have something right now. What I would request is the opportunity to submit the bed date to Mr. Stockton. It is just a matter of getting the bed date.
Okay, where are you working at now?
I work for 10K Dairy, so it's a dairy operation.
How many hours a day do you work?
I work around 6 to 8. I do.
I don't really know what improves the situation if we take him out of his job and see him something else. I know you've tried.
The problem we've got is I think the alcohol use causes severe health problems. And then, according to Mr. Collins, and then we can't leave him on probation. He's going to keep consuming out. That's the problem we've got. And only Mr. Keith is out.
You're right. Who you live with, Mr. Keith?
By myself.
Do what?
By myself.
Yeah. Do you live on the farm there that you work on, or?
It's pretty close to the farm. Yeah.
Y'all, when you do breathalyzer test, checking, how y'all checking for alcohol?
Your Honor, I conducted a home visit in August. after he had gotten back from, his short-term treatment and moved back into the block house. Up on the home, doing the home visit, I could smell alcohol from his breath, and I breathalyzed and he blew a .098. That was like around noon, so. My concern is he almost died the first time.
And the solution would probably be if he would do what probation and parole had lined up the first time. I think it was through journey period.
He completed a journey period.
Were they gonna give him some kind of app that he had to log into and be tested or something like that?
I'm not 100% sure.
Something like that would be fine.
He was gonna stay with his sister. She was gonna help him stay on the right track and try to help him through the situation and stuff. He decided to move back to where he was at.
Find him a rehab to go into. Here's the problem, Mr. Keith. If this was easy to do, you would have already done it. You know, alcohol can be addictive just like any other drug can be. It appears to me that you got some social issues living by yourself, that sort of thing probably going on, but you'll be able to find a job when you get out. You probably lose your job when you go into this. I don't know. Is your employer going to be accepting of you going into rehab somewhere and let you have your job back when you get out?
Yeah, I went through 60 days, but I can get the total child support paid by Monday. Get it all paid off.
I'd say at least let him have opportunity to pay out and review it next month.
Okay. Let me tell you what we'll do. You be back here on the 8th. We'll dismiss the case by agreed order and everything. And then it'll be up to you where you drink yourself to death. You know what I mean? I can't do anything about it. And I'm not being critical of you, okay? I had people in my family who drank themselves to death. I had an aunt that just drank herself to death. There wasn't anything. She drank for years and years and years. And we weren't associated with her that much. She lived in California, came back home to die because she'd ruined every organ that she had. You know, I can't do anything but say a prayer for you, man. So you have that paid off and we'll get it out. If you want to voluntarily go into some kind of treatment thing, I think it'd be a good idea, okay? So you'd be on October the 8th. Okay.
Your Honor, for the court's information, I've already discussed this with the Commonwealth. I will not be available for the October court dates.
You'd be agreeable to sign an agreed order. If
I hope so, Your Honor.
finish
Yeah,
up.
I will
We'll
be.
do it.
Yeah.
Yeah, okay, good luck to you, man.
Thank you.
Okay. Okay, let's see who we have left here on this out of custody docket. Anybody who hadn't been called here, raise your hand.
We've got Miss Marley.
Kri Marley.
Diego Morales.
Yeah, those two.
Did we ever find Diego Morales' attorney? John Caudle. Was he on the line earlier today?
He was driving in his car and I stopped the video.
He was the one that had court where?
Federal.
Federal court. Oh. Well, issue an order holding Mr. Coggle in contempt for not being here and fining $250. Mr. Morales, you come back. Are you in a negotiation phase with?
Not that settled the case.
So he just needs to come back. You come back here on October the 8th with your attorney. He didn't show up today and I fined him $250, okay? So you.
Our different one, because we've been doing this for a while.
Well, I know you have.
It's private, so it's.
He's a private attorney though. So if he, I'm going to tell you what, if he doesn't appear on October 8th and get it done, I'll let you get a copy of that and go it over with the public defender's office or somebody else and finish it. You won't have to come back after that, okay? See you. Thank you for your patience. We're going to Kri Marley. Commonwealth versus Kri Marley. Kri Marley has been previously up here. What have y'all got going on that case?
Your Honor, unfortunately, I believe the situation is the same.
What is the situation?
Your Honor, we have a counter offer. We've expressed to Ms. Marley what the offer is or what the offer on the case is. She has not indicated that she wishes to accept it nor authorized a counter.
Okay, well, let's set a trial date.
I thought we got to the trial, but. Okay.
Don't confuse me. We were,
No, I understand that the co-defendant in this case.
Are you taking over now, Mr. Howland?
Same
Are
thing.
you taking over now? Sit down.
well, let me, wait here. Who is the co-defendant? We said something.
Yeah, I know, we were gonna set a trial date on this case.
Well, did we set one on the other case?
No, because
I'm
he's not
just
been
asking,
served.
I don't
He's not
know
been
who
served.
who?
He's not been served, the co-defendant has.
Okay,
So we'll try it twice. I don't care.
okay. What is this charge you're trying her on?
Possession.
Okay. This is a one-day trial?
Yeah.
Number 12. Just for my information, it's kind of slipped. Do we start with that Robles trial on Monday?
No, it's been
It's
continued.
been continued. It's still on my docket. The Russell case. Been continued also, right? Is that correct?
That's correct.
When can y'all be ready for this?
Your Honor, I believe that we both have some availability that last week of October. Is that correct?
Yeah.
Well, what about the first week of October? Are you available first week of October?
Yes.
Your Honor, I am unavailable. I have trial in second. I think it's just a 2-day trial.
This is gonna be a 2-day trial here?
No, Aaron, it's gonna be a 2-day trial.
Well, let's do it on the 3rd then. Okay. Is that all right with you?
3rd of October.
3rd of October.
Let me go check the lease.
Okay.
So we're good.
Let's see. Commonwealth versus. Marley. Okay. It's fine. Now, do we have any other thing on the docket for today?
James Bristow is reduced to a very.
James Bristow. Where is that? What's the number on that?
The very first one on the address.
Oh, yeah, there it is. Commonwealth versus James Bristow. And then we're going to Barron County. Are you James Bristow? This is 24CR0033. You born in 1990?
Yes, sir.
Last 4 digits of your social security number 8640.
Yes, sir.
Okay, we're on a pretrial conference. What do you got? What's Commonwealth have?
Best of my memory, we had this case settled, but he was in specialty court program. He didn't qualify. I asked the court for a post sentence, and I think you said the police side. So I guess we think negotiation, they can start from square one. If we don't get settled, we'll get it done.
November 1st and November 14th. Okay. Now that,
November instead of.
I've got it marked out over here, October. What is the negotiation day in October? October 4th and October 8th. October 4th and October 8th. Okay, now is there any other thing, any live docket people here? Is there anybody here to see the court that's name hasn't been called? Would anybody admit that they're not here, if they're here, the name? Okay, let's go. Christian County's never on the docket. Let's go to Roeder. Are you on Roeder Correctional Complex? We got Mr. Padilla on there. Could somebody from Department of Corrections call Roeder? We had them scheduled, I never did appear. Let's go to Barron County. David Bridges for arraignment.
Good morning. Can you hear me?
Yeah, Commonwealth versus David Bridges, 24 CR 0072. Are you David Bridges?
Yes, sir.
Born in 1970?
Yes, sir.
Last four digits of social security number 6243. Do you have an attorney?
No, sir.
Have you filled out an affidavit? Can you afford an attorney?
Not at the present time, sir. Unless I'm released from jail, I can.
Okay, I'm gonna appoint the Office of Public Advocacy, and if the pretrial folks will have a affidavit filled out, please. Okay, Mr. Bridges, were you born in 1970?
Yes, sir.
Last four digits social security number 6243.
Yes, sir.
The grand jury of Monroe County has in turn returned an indictment charging you with flagrant unsupport. You understand what that is?
Yes, sir.
Okay, Counselor, do you acknowledge the identity of Mr. Bridges, waive formal reading and arraignment, enter plea not guilty, reserving all pretrial motions?
Yes, Your Honor.
Okay. Set a negotiation day up for October the 4th, and the next court appearance is October the 8th. Signers, let's go with it. Okay.
Thank you.
Excuse me, Judge. Judge, may I say something?
Well, it depends on whether it's about your case or not. You be careful not to incriminate yourself, but go ahead.
Yes, sir. Sir, I was just released on parole July the 30th, and I was out 17 days. And during that time, I went to a DOC halfway house. Okay, and I got employment while I was there, and there's like three parole officers come in and out of that place all the time. And I know my bond's like $15,000 surety. I mean, I have to sign in and out of the place, and I mean, I know it's flagrant non-support, and I already got a job. I got a check up there waiting on me. If I can get back up there to get my check.
I'll tell you what, I'll let your attorney will come over and talk to you about that. And if we can,
Yes,
we reach some kind of agreement, but where do you live normally?
I was living in Tompkinsville, but I moved to Louisville because I want to change. I'm trying to change my life. You know what I'm saying? Get away from the drugs.
She'll be over to talk to you. She'll be over to talk to you, see if we can reach some sort of agreement. See if we can.
I'm on parole, sir.
Wait just a second. Your attorney's talking right now, okay?
Okay. I mean, if I can get a whole water bond, so all I'm trying to get back up over and start making.
Wait just a second. Okay.
Okay.
David, we'll come over there and talk to you. I'm already talking to Mr. Stockton to see if there's anything we can do, okay?
Okay, I'm just trying to get all our bunch, so I can get back.
They're gonna work with you, okay? They'll be over, okay, thank you. David Buck. Commonwealth versus David Buck, 24 CRs 078. Are you David Buck?
Yeah.
You born in 1954?
Yes, sir.
It's 4 digits, social security number 4580.
Yeah.
You're here for the purpose of arraignment. Do you have an attorney?
Yeah, Judge Bell.
All right, he's right here, Mr. Bell.
I hadn't been retained, David. I hadn't talked to you or anything. I don't care to come see you and you can talk to me about it, but.
But I got my lawyer, got all of you.
What did he say?
What did you say, Mr. Buck?
My son got all of you.
Thought his son got a hold of you.
Oh, he hadn't, David. I represented him, but I haven't talked to him about your case. I'll be glad to call him and talk to him if a judge will permit us to do that.
Okay.
You have money to hire an attorney, Mr. Buck?
Yes, sir.
Okay, well, I'm gonna let Mr. Bell stand in for the purpose of arraignment only. Get you arraigned and then see if y'all can make some kind of arrangements. If you can't make some kind of arrangements with him, then after that, I'll let you put an affidavit down. If the pretrial folks will let him do an affidavit, we'll see if you're eligible for a public defender. Okay, you have a right to remain silent, Mr. Buck. The grand jury of Monroe County has returned an indictment charging you possession of controlled substance in the first degree and possession of drug paraphernalia. You sign a reciprocal discovery order. They'll give Mr. Bell the stuff, and you have your son contact him. You'll be here on October the 4th. I don't know where you're gonna represent him. If Mr. Bell does not represent you, you'll be here on October the 4th for negotiations and October the 8th. Now, Mr. Bell can't be here on that date. He's got a conflict. If he represents you, you'll need to be here on November the 1st and November the 14th, okay? What is his bond, Mr. Buck's bond?
Your Honor, it's 15,000 clerk approved surety.
Okay, why hasn't anybody made your bond, Mr. Buck? It's just $15,000 surety bond. That's, anybody can sign that just about.
I don't know.
It's had several charges, I know in district court lately, so maybe nobody wants. We
Yeah.
come back in the paper, actually had a confusion with his son. Because I told Mr. Bell, I said, I'm probating his son, he's getting all these meth charges in district court, and it turned out Mr. Bell said, no, it's his father's.
Yeah.
Do you want me to call Josh and see if we can get somebody to sign your bond for you, David?
Yeah.
Okay.
Okay, I don't know whether he's got any holds on him or not, but we're gonna have, I'll put him on for October, that October date. And then if you're representing him, then you can move for a continuance to November. Like not somebody else to represent him, okay?
Yeah.
Okay, thank you. Brockman Carter.
Yes, sir.
The Commonwealth of Kentucky versus Brockman Carter, 24 CR 0030. You are Brockman Carter. You're born in 1983, last 4 digits, social security number 0829. Here for a pretrial conference. You want to come around? Okay, what do you have on this one?
Well, we didn't negotiate the case last Friday because Mr. Carter wasn't present. I don't know that we would have got any resolution if he had been, so I don't know if that matters.
I got my dates mixed up. I apologize. It was an honest mistake.
Over here by.
He had advised me, Judge, that he wanted a trial, and that was a lot of the reason that he wasn't present, because he had called and just said to get a trial date. That's what you wanted, wasn't it, Brock?
Yes, sir.
And that was the main reason behind that. I was here on his behalf, Your Honor.
Well, Explain to me, I got bond calls and everything, bond
This is-
revocation work, explain to me here.
Your Honor, I have, for the last several weeks, I've been getting complaints in my office that Mr. Carter wasn't abiding by his home incarceration conditions. I talked to Mr. Richardson about that. And then after he didn't show up for his negotiation day, I told Mr. Bell, since he was going to set it for trial date, I wasn't going to hold that against him. But I called Deputy Richardson again. I said, did you get that information? I said, I'm still getting complaints on the bond. He said, and I wanted to know where he was. And he said, I'll have to check and get the records. And then Mr. Richardson and I, Deputy, talked earlier this week, and we'd found out that he hadn't charged his device since last Friday. And so I asked Mr. Deputy Richardson to get a warrant for his arrest then, because he wasn't abiding by the terms of his home incarceration. And then the arrest warrant was issued, and then evidently there's been a resisting arrest charges and different things since they went out and arrested him at his home.
Your Honor, the charger to my ankle monitor was malfunctioning. But Your Honor, when they first put me on the ankle monitor, after I paid my 2 bonds, they also put me on an ankle monitor. We objected because I live alone, Your Honor. I mean, I to eat, to work, doctor, I don't have anyone helping me. I mean, my grandma's 91 years old. I'm looking after her. Not been able to see my son all summer long, Your Honor. So I was trying to keep Ricky Richardson. I did keep Ricky Richardson updated as to where I was.
Brock, I would hold off on talking right now. Let me talk for you a minute, see where we land.
Yes, sir.
Judge, the only thing that I would say about Mr. Carter, and I think the most important thing the court should take into consideration is that he does live alone. And I think a lot of the movement that he was doing was to get food and see about family and things. And that probably wasn't permitted in the amount that it was happening. The only thing I can say about Mr. Carter, I have seen his records and things. He is somebody that has served.
Here's the thing about it. You're giving testimony now. The problem that wait a second. The problem that I have here is he wasn't abiding by the bond condition by moving around, but he hadn't charged the instrument up. And when they go out against him, he resists them. Now, did I understand that he had to be tasered?
That's my understanding. I hadn't seen the report. I just got hearsay, but I know he was charged.
So there's something going on here, Mr. Bell, and I don't really feel inclined. I don't know. He's on bond. We can set it for something else. Nobody's asked for a bond reduction.
Well, I think there would need to be a hearing because Deputy Richardson testified that he let him go out those places to get food and stuff, but he didn't give him permission to go to Bowling Green to get something. So
I had to get a cell phone.
Hold on, Brock. Hold on a minute. I think, Judge, what I was trying to explain, and I think it is a strong mitigating circumstance. I think some of the problem why that they had to go in and tase him is his military service to the country. He's been 2 deployments in Iraq, or I'm sorry, Afghanistan. He's done a lot, I feel, for the country, and I think it's impacted him and affected him in certain ways, Judge. Not anything he couldn't function or anything of that nature, but I just think that his reaction would be a little bit different than, say, mine, who had never done much of anything really, for the country, or anybody else really, to be quite candid about it. I mean, I'm not trying to be funny. It's just the truth. I don't like that about myself, but it's the truth. But somebody like him, even though they sometimes transgress a little beyond our understanding, I think we ought to try to consider what they've done. And the only thing I'm asking is
we'll schedule a hearing then.
Is there any way we could let him back out with a sanction and put him back under?
I cannot do that right now because the ankle bracelet wasn't on. It wasn't charged. They said he wasn't there. They go out to check on it to get the warrant, and they have to taser him. Now, I have the most sympathy for someone that's struggling with some issue, but he's a danger to these officers, and he's a danger to himself right now, unless you can prove it otherwise. And I don't know how long he's going to have to stay incarcerated here, But I don't feel without hearing what actually went on.
He was going to get a charger. I think his charger had torn up is
Well,
what.
again, Mr. Bell's testifying.
See, I mean, I don't have any evidence in front of me. There could be
It's no
mitigating.
different what you was doing, wasn't it? But I understand.
Well, I'm not deciding based upon what he said either. You know, I mean.
The state police broke my door down and it's unsecured right now, Your Honor. I will abide by the bond.
Be quiet. You need to be quiet.
Yes, sir.
Okay. When do you want to have a hearing on it?
Whenever, I'll leave Mr. Deputy Richards there and I'll leave the officers that went to do the arrest. That's all I'm pressing.
Okay.
I'll have to have time to look over these maps that Deputy Richardson's furnished.
Okay, where are we at next week? Cumberland County? We can schedule a hearing next week in Cumberland County.
I'll be there the 19th
That way
anyway.
you'll have an opportunity to talk to your client, prepare for your case.
Yes, sir.
Okay. And
We've put the roots on for discovery. You should have them.
okay, thank you very much. Your attorney will be over to talk to you, Mr. Carter. Seth Graves. Seth Graves.
Yes, sir.
Commonwealth versus Seth Graves, 24 CR 0075. You Seth Graves,
Yes, sir.
1988.
Yes, sir.
Last four digits of your social security number are 4888. You're here
Yes,
today. Purpose of arraignment, you have the right to remain silent. The Office of Public Advocacy represents you. Y'all represent him in district court.
Yes, Your
I'll
Honor.
continue that.
Thank you, Your Honor.
The grand jury of Monroe County has returned an indictment charging you with burglary in the third degree, wanton endangerment in the first degree, theft, unlawful taking or disposition, and being a persistent felony offender as far as burglary and wanton endangerment. You understand those charges?
Yes, sir.
Okay, we'll go ahead and you entered a plea of not guilty on behalf of the defendant, reserve all pretrial motions. Is that correct? I'm signing a reciprocal discovery order.
Thank you, Your Honor.
Schedule, is it October the 4th? Is that right? October the 4th for negotiation and October the 8th for the next court appearance. Okay, your attorney will be over to talk to you, sir. Okay.
Yes, sir. I'm in treatment. Is there anywhere I can go back to treatment? And
Well, we'll let your attorney talk to you about that, and then she can contact the Commonwealth. We'll determine the conditions, your bond or treatment then, once she talks to you. Okay, thank you. Shelby Horton. Shelby Horton.
Yes.
Commonwealth versus Shelby Horton, 22 CR 0094. Are you Shelby Horton?
Yes.
Were you born in 1996?
Yes, sir.
Last four digits, social security number 5014.
Yes.
You're here on a probation revocation. What does the
Yes.
Commonwealth have to say?
She has a 3-year sentence on possession of a controlled substance, first degree. And basically she absconded after May the 1st of this year. And we got Ms. Baker on here to testify.
Who's your attorney?
Don't have one.
We sent we sent the
DPA.
motion to DPA and King Garrett. No, we didn't send it to DPA. King Garrett was her attorney before she entered the plea.
Well, I've got DPA on here.
Your Honor, she
You want to come around here where I hear you?
Or on the underlying case, she had originally been appointed to our office. However, shortly after that, she had retained Mr. Garrett. And as Mr. Stockton stated, we do not have a motion on her.
Should have been sent to you all too.
What do you say, Mr. Garrett?
Judge, I can handle it. I'm not retained for it at this point, but I can handle it. That's fine.
I didn't think you did anything for it.
I didn't know I'd ever see a rule day where Mr. Garrett seemed like the hero. But, Mr. You heard, tell us about the probation revocation.
Yeah, she was
Absconding. Does you want to talk to her about it first sometime?
Yeah, if we can do that. I'm gonna be here on the 8th, Judge, if you want.
Okay, well, let's continue this to October the 8th, and out of the goodness of his heart, Mr. Garrett's gonna come over and talk to you about this, okay?
Thank you.
Thank you. Jose Robles.
Yep.
Commonwealth versus Jose Robles, 23 CR 0050. Are you Jose Robles?
Yep.
Born in 2000.
Yep.
This 4-digit social security number 4313.
Yep.
Okay, what do we have here?
Judge, this is a case where we agreed to set it over to November 1st for the informal settlement conference and the 14th for the pretrial because we're still waiting on some evidence.
Is there evidence that has to come back, Mr. Robles, and they've agreed to continue, have a negotiation if that comes back on November the 1st? And the next court date's November 14th. Both of them are conditions of your bond, okay? Your attorney will be able to explain to you. That's the one where the fingerprint just came back.
Yes.
And then they had some other evidence that they're gonna have to look at then, okay?
Yes.
You'll be over to talk to you. Thank you.
Judge, could we call a quick one out of order?
Well, I just got two more. Robert Simpson or Shandra Warren, which one?
Well,
I
Ashley
took
Lewis.
her off after you contacted me.
Oh, okay, never mind. Problem
So we
solved.
can put her back
We're
on.
gonna put her on for October, right?
Okay. I mean, if they're just two people, I'd gladly call one out of order for you, just for you today.
I can probably do some charity on it too.
Okay, Commonwealth versus Robert Simpson. You Robert Simpson,
Yes, sir.
1991,
Yes, sir.
last 4 digits, social security number 5031. You're here
Yes,
for
sir.
arraignment. You have the right to remain silent. Your attorney, public advocacy is here. The grand jury of Monroe County has returned an indictment charging you with trafficking and controlled substance in the 1st degree. You understand that charge?
Yes, sir.
Okay. Counselor, you acknowledge the identity of the client received indictment, waive formal reading and arraignment, enter plea or not guilty, reserving all pretrial motions.
Yes, Your Honor.
Okay, I will set this for October the 4th and for a negotiation, and October the 8th for the next pretrial. I'm signing a reciprocal discovery order, which requires the Commonwealth to provide your attorney information. What is the bond in this case?
Yes, Your Honor, it's $20,000 per surety.
Okay, you should be able to make that, Mr. Simpson. That's not a very high bond, okay? Okay, thank you very much. Shandra Warren. Shandra Warren. Shandra Warren. Commonwealth versus Shandra. Are you Shandra Warren?
Yes, sir.
Born in 1980?
Yes, sir.
4 digit social security number 8790.
Yes, sir.
We're here on 24 CR 0070 for the purpose of arraignment. You have a right to remain silent. Were you represented in district court with Office of Public Advocacy? Public Defender's Office, or?
I need a public defender.
Yeah, we'll go ahead and get an affidavit signed, and I'll, on that, I'll appoint the public advocacy and finalize it when you fill out the affidavit. The grand jury of Monroe County returned an indictment charging you with possession of controlled substance of 1st degree methamphetamine. You understand what that charge is?
Yes, sir.
Okay, you acknowledge the identity of client received indictment, waive formal reading and arraignment, enter plea or not guilty, reserving all pretrial motions.
Yes, Your Honor.
Okay, I'll set a negotiation day for October 4th and the next pretrial for October the 8th. Sign a reciprocal discovery order. Your attorney will be able to talk to you. What is this lady's bond?
Yes, Your Honor, it's $15,000 per surety.
Yeah, your bond is only 15,000 clerk approved surety, so virtually anybody should be able to come in and make that bond for you. And both of those dates, October the 4th at 9 and October the 8th at 9 are conditions of your bond when somebody signs it, okay?
Okay.
Okay, thank you. Now, the Barron County Jail, is there anyone there that you think is scheduled that I haven't called?
Excuse me, sir. Judge, do I have a PBO, probation violation? Mr. Robert Simpson.
Judge, I don't know what it is that he is asking.
What are you saying? I can't hear you.
Do I have a probation violation where I can't get out or?
Yes, Your Honor. Yes, Your Honor. It is scheduled for the October date.
Yeah, that'll be in front of me too.
Yes, it will.
Yeah, I didn't know you had a probation violation, so it's scheduled for October the 8th. Okay.
And Robert, I'll be over to speak with you soon.
Okay.
Okay.
Thank you. Okay, well, you're excused, Barron County Jail. We never did get Roder on there. Now, was there anyone else that we need to call, Mr. Stockton? Mr. Stockton, is there anyone else?
No, I don't.
Okay, well, that concludes this lovely session of the Monroe Circuit
We
Court,
got show cause.
and we'll accept for the show cause docket. Okay. I'm gonna take a 5-minute recess here before I start the show cause docket.
Never did it.
Yes. Just get her a bed date somewhere.
So I'll do the referral.
Okay.
I'll do the referral to Bethany. And then.
And I got one more too. I can't remember what Jason told me. I got another guy too. I wrote it down. I can't think of the name. But they said if we can get him a bed date too, let him go too.
Okay.
I remember who it was.
Okay. If you think
y'all
about
are so much easier than me. They have to be using and sex and it's a lot and lots. I hate it. I hate it. Beth gets me down.
Yeah.
Dakota's going.
So yeah, we'll get her a bed day, just let them get to you and to Jesse and then. So, thank you very much. Yep.
Okay, let's go back on the record, please. Back on the record. Commonwealth versus Herschel Hammer. Got anything to report on Herschel Hammer? Have a arrest warrant issued for Herschel Hammer. He can purge himself by paying $215. Whoop. I got Herschel Hammer on the next page here for $7,400. Is that restitution? Where is Herschel Hammer? Around here somewhere? We'll put an arrest warrant out, let him pay $500, purge himself, have him appear on October 8th. Devon Howard. He's in spark recovery. Put him off put him on the docket on October 8th. For all of his there. Does anybody, do they have to work while they're in Spark recovery?
I think it usually depends on the phase.
Yeah, I think after a while.
I want him here. I want him here next real day, okay? Sean Jones. Sean Jones. You paid anything? What's the story, Mr. Jones?
I just got out of jail about 3 weeks ago, something like that.
Well,
And I
that's
hadn't got a
3
job
weeks
yet.
ago and you hadn't paid anything.
I hadn't got a job yet. I lost my job when I was in jail. I done 90
Well, I
days.
know, but 3 weeks, you could have picked up cans or done something to make some money.
Yeah.
Okay, you have $50 paid by the 4 o'clock tomorrow or report to the Barron County Jail. Okay, $50. You pay $50 a month on that, okay?
All right.
Okay, bye.
Thank you.
Sean, it's another one there. You got 1,200. Well, you just pay $50 a month on toward all of it, okay?
Okay.
Billy Ray Key. What's the story on Billy Ray Key? Do what? Issue arrest warrant for him to purge himself by paying $265. Shannon McGuire. Do what? Have an arrest warrant to purge himself by paying $200 toward the 740 and have him here on the next court date, October the 8th. Jesus Padilla, he's incarcerated, Passover. Is this the father or the son here?
I'll only had on the day and see what his rear earth is. This is not the one that was on today.
So he's loose here. This
I believe.
Horatio?
Yes.
He got picked up by ICE, I'm pretty sure.
we'll put a $200 payment, arrest warrant, $200 payment. Purge himself. Commonwealth versus Alicia Russell. She's in jail for what?
Or William boat was picked up today, same day. Probation violation.
Okay, put them over for October the 8th. Travis Smith. What did he pay?
$300.
Okay, put him on the docket then for October 8th. Timothy John Tucci. Issue an arrest warrant and purge himself for paying $90. Dakota Williams, you said was picked up.
He was here this morning. I've got him back there if you need to see him.
What's he in jail for?
Probation violation.
Put him over. Is he gonna be heard next month?
No, he's
You get the vote?
Williams,
He's supposed to, he's
you
supposed to.
refuse to revoke him and you're gonna send him to long-term treatment in lieu of revocation and give him a furlough to go to the doctor this afternoon.
Yeah, we'll put him on to next month. Okay, that concludes the show cause docket. Is there anything else? Okay, then we're in recess till 1, is that correct?
10 minutes. Oh, no, it's only 12. Gosh, I'm going far behind.
Okay, let's go off the record then, off the record.
It felt like we're way behind. I'm going home, like, taking off my shirt, found one on board all day.
He's working his way out. At least he's swimming, so. It's pretty good for me. Don't bother.
You're using that.
I've got this trick figured out. Go back to wash your garden.
I'm remember when my parents first got divorced, my dad. So, remember he asked me if I would wrap his Christmas presents, first Christmas. I was like, yeah, he just brings them over in bags, like garbage bags.
Lacey's done that for me for years, so. She'd do all the Christmas shopping and everything, and she'd wrap them for us, Christmas morning, hell, it was just a big surprise to me.
It was good. Yeah, that's how my husband.
14th, okay?
Okay. And then we'll know more about his treatment.
Okay, thank you.
That's what we hear in district court on Zoom.
I'll submit an order.
We'll submit an order to that effect.
Rich versus Rich.
It's at whatever support.
Rich versus Rich.
Judge, this is our motion to establish child support and medical support. Sean or Heather Rich? Staples, you're still under oath. You're familiar with 18 CI 27. Did this arise from a divorce case?
Yes.
And then Miss Rich asked us to establish child support. Is
Yes.
that correct? And you've done the calculations based on the Kentucky Child Support Guidelines. It falls at $312 per month for the two children. We ask that that be effective until effective September 1st.
Sounds reasonable. Order. Brown versus Scott.
Continue to October the 8th.
Wilson versus Shelton.
Judge, this is our motion for default judgment. We filed an affidavit. There is proof of service in the file.
So seems appropriate, submitted. White versus White.
Second.
Ms. Staples, you're still under oath. You're familiar with 19. Have this civil number. I've got the CR number on it. 03 CI 144. Is that correct?
Yes.
And Mr. White, Tony White is before the court,
Yes.
given notice of this hearing. Tammy is the.
Tammy White
Oh,
is the-
all right. Tammy White is the obligor in this one, and she has an arrearage of $669.39. Is that correct?
Yes.
She last made a payment on April the 12th, 2024. Is that correct?
Yes.
Judge, we just ask that you hold her in contempt and allow her to purge. She is capable of making this support. She's not incarcerated nor a member of the armed forces.
Correct.
It's an 03 case. You can tell Frankfurt's been getting on us about.
Okay, thank you very much. That concludes your business.
Frankfurt, because the Attorney General takes over child support July 1st. And there's discussion of eliminating the regional offices. So regional office also.
Yeah, show their worth, right? Okay, I'm gonna go through these the way these are filed. They filed differently in the docket. Okay. Hollingsworth versus Asher. Hello.
My motion for trial date, Your Honor.
And you asked for some relief from discovery deadlines. When can you get that doctor out there?
Well, we have, really the only discovery we have left to do is for trial, with the exception of two nurses. There's a nurse practitioner and a nurse we want to take for discovery purposes only. And then there are 5 doctors that we believe we need trial testimony for by video. So we've already taken 2. I think there's 5 left to do. One's in Kansas City is probably the most onerous one. They've left. They were in locum's physician at the time. In looking at our calendars, I don't really think that's probably going to be the problem as far as getting a date with Your Honor. I think my calendar is almost impossible until probably early January. And I don't see any problem getting those video depositions done in that type of time frame. So that's kind of
How many
where
of them you gonna use for trial?
all of them is.
How many of them are there though?
There probably will be 7 total. The 2 we've taken so far.
Were they gonna be present to take them?
No, this is trial testimony I'm talking.
No, but they're gonna be present to give the testimony in the courtroom, or are you gonna take them over Zoom and let me preside, or what are you gonna do?
Well, my intention is to present that testimony by video that we take in the meantime. So I don't have the rule committed, but there is a rule that allows trial testimony from MDs by video deposition. And that's what I'm discussing.
I know, but some people want the judge present.
Well,
you know what I mean? Do you do that?
That's not been my practice, Your Honor, with all candor.
Well, we don't do a lot of doctor's testimony in this circuit. And in the past, people weren't there so that it appears to the jury more trial-like, you understand what I'm saying? So then after we do that, if we have objections and things, there'll be some editing to do and
Yes,
things
sir.
like that. So editing's not as much problem as it was at one time, obviously. Have y'all got your calendars with you today?
Got it, Judge.
I do, Your Honor.
This case is 22 case. These medical depositions, they've had medical records since 23.
I'm gonna let them take depositions, so.
Well, all right, but I mean, this case needs to be tried.
I'll do my best to meet your standards on that to get it over with.
I appreciate it, Your Honor.
I had discussed with Mr. English the week of January 6th. I'm available that whole week. He and I went through our calendars.
You ought to have it, are you gonna have all of them that week?
Yes, sir.
All the doctors, you got 7 of them?
Well, I guess I need to discuss with Buzz what Your Honor is telling us, because my anticipation was we'd have all that in the can, frankly. That we'd have all the doctors' testimonies by video, and all we would need to do before Your Honor would be to play that testimony. Now,
So how many of them don't you have?
there are still 5 left to get, including
Well,
the
that's the ones we're talking about then.
Yes.
What you do present and don't present is subject to you presenting your witness list that you're gonna call at trial and him looking at it to see if there needs to be any editing of the things done or any objections that were made to see if we do that and ready to roll. The good thing about it is you don't have to wait long here to get a trial after you do it, you know?
Mhm.
So, yeah, you think you can have the testimony finished by the end of January?
I think I can get it done by the 1st of January. I mean,
Okay, well, tell me
Yeah.
tell me what it is and I'll set a trial date.
My anticipation is to have all that in the can at the end of the year, Your Honor.
Okay, and that would be December 31st, right? Okay, well, let's go into January and set a trial. Then.
Yes, sir.
See how much influence you have on me, Mr. English? You just got me to advance that right away.
And I know he wants a trial date, Your Honor, and frankly, my
Everybody
client does
does.
too.
People want these things resolved. They hang over them and things like that. Let's go to January. I don't have my rule days.
They're not scheduled yet. That'd be the 9th, 16th, and 23rd.
Now, you're in the Monroe County Bridge case,
Yes,
right? So that's scheduled for the 27th through the 31st, correct?
Correct.
Okay, so I would assume that you'll want a little time before that, or,
Yes, sir.
yeah.
At least a half a day. Right.
Before that trial? Yeah. How many days do you think it takes to try this case?
I think it's a 3-day trial, Your Honor.
Okay, what about, January the 6th?
That's the week I'm available.
Okay,
That'll work.
yeah, do you need any, I guess y'all by agreement will try to agree on whether the tapes need, any rulings on it or something like
Yeah.
that?
I think we.
There's a date. We'll need to agree upon a date by which to file objections to any.
December 12th. Objections by December 12th.
Can we just include that as a deadline for motions in limine of any kind? Your
That's
Honor?
right. Let's do all, the last pretrial. And I guess, you have already submitted instructions, have you?
I don't think we have. I don't think either party
I don't
has.
think I can submit mine today. If you want to see. It's just a will contest.
Yeah, I mean,
Pretty simple.
Just a will contest. Well, if you get your instructions, my instructions in, so. I've done a bunch of will contests. They've always been very unpleasant.
They are the closest thing to divorce work I think you can do without doing divorce work.
Yeah, that's tough. Yeah. Okay. Anything else in this case?
That's all.
Well, do you want us to, is that a date?
Well, if you've got anything that needs to be heard in front of me on 12th, have the motions filed to be here on 12th. If there's anything I have to decide for the trial that's coming up, and we'll decide it that day. So, not only make your motion, but brief your position if you have something that you're not in accord on.
You may see us between now and then on a very brief discovery issue if we can't work it out. I don't want to get into it today. There's a good chance we'll work it out anyways.
Okay, well, that's good. I saw a picture of your father on Facebook, so a big celebration. You give him.
Very on.
Yeah, it's a great honor. Well, he deserves it. He's a man of stature. Okay, well, y'all have a nice day.
Thank you, Judge.
Yeah. Okay. Cornelius versus Cornelius.
That's just my motion. Set it for trial. And I talked to Mr. Wilcutt, we discussed, mediating the case also, but, we haven't done that at this
Okay,
point.
I don't have a domestic relations commissioner, so I'm going to be hearing these things myself. And so what I'm going to do, since I'm not a family court judge who hasn't done a lot of that sort of stuff and have exceptions, what I'm going to try to do is I'd like people going into mediation, but what I'm going to try to do before we sit for a trial or a hearing on the thing, I want to meet with the lawyers and the parties to see what we are in accord on and what evidence will need to be given about the contested issues so that we can stipulate as many things as possible. What do you think the main issues that are not in accord now? Is it, do we have pensions? Do we have land? Do we have?
They got a house and lot, it's got a mortgage on it. I don't think either one of them was living in it.
Was it
Probably needs
definitely
to be
born
sold.
after, it was bought after they were married? Yeah. Okay, so is there anything else?
Custody and visitation.
Custody and visitation.
Do what?
The primary issue is going to be child-related issues, custody and visitation.
How many children are there?
Two
And
small
you
children.
live in Florida, do you? Or where do you?
He's living in Kentucky right now, but he's
Right
potentially
now.
gonna move.
Okay, how many children are there?
Two, Judge.
How old
There's
are
11 and 3.
11 and 3. Okay. Okay, well, then so custody's the main thing. Can you work down through the property things and see if there's anything about property that we're gonna need to address?
Just quite frankly, we've really haven't got into the details yet. There was a period of time, I think, when Miss Cornelius was in rehab and, so she's been out of pocket for a little while.
Okay. Okay, well, when do you want, you say you want to go into mediation with someone?
Yeah, we're willing to, we don't have an objection. I don't think Mr. Wilcutt has an
I don't have an
objection.
objection to attempting to mediate this case. Mr. Hampton and I discussed maybe getting a trial date later this year to have one on the books and try mediation prior to that trial date, see if we could.
Well,
resolve the case.
what I do is by not sitting, putting things on the book until we're gonna try them, I can get you a quick trial date.
Okay.
There's no problem.
Okay.
I can pick a Monday or a Friday or something like that and give you the whole day. I sure it won't take over a day.
I don't think it'll
You
take
know,
today.
and we
Do
can.
you want us to?
The problem we have and what my staff lawyer says is that if we don't get a date when everybody's here, when you start calling back everybody, I had one today that the guy said, oh, I absolutely can't be here in Monroe Circuit Court because I'm in federal court today and y'all just meet one day a month. And I said, well, that's easy to solve. You just mark off that one day a month and tell the federal judge that you're tied up for that day. I don't care whether they're a federal judge. I respect federal judges, but they need to respect us too.
Right.
So, so if you got your calendars with you?
We do. Judge, what I was
All
gonna
right.
possibly suggest, if you want us to try to mediate it, which we can do that pretty quick and then come back to you to get a date for you.
Okay.
Without.
Okay, well, you
burning-
don't have to come back here. Let's just put it like this. You mediate it and tell me when it's stalled. Okay, and then you call our office with your calendars.
You can do that.
And I want to be involved in it, okay? Because people have caused me problems by not agreeing and with the staff lawyer. So if y'all, when you call back, if you can't agree on something, I'll just set something.
Right.
Okay? Okay, I'm all right.
Yeah, so we'll just call your office after the mediation
Yeah,
and
yeah,
figure out if we need you or not.
yeah. And you've done all the discovery
Yes.
as
sir. I
far
think
as
we're
the
fine discussing
incomes and
discovery
stuff like
bonds.
that.
Yeah, he and I work together. We don't have any issues.
Okay, good. Well, good. Y'all can help guide me through my new role as family court judge. I switch hats here all the
Yeah.
time.
God bless you is all I can say.
Yeah, I didn't sign up for it.
I know.
You all just email me so we can set up a conference call when you're ready, so that way we're not.
Ron and I can.
Yeah.
It's not a problem.
Okay, thank y'all very
Thank you,
much.
Judge.
Okay, Turner versus Guffey.
Yes, Your Honor. I represent Amber Turner. This was
Amber Turner.
it is, yeah. We were on the docket last month and Bruce Brown was representing Shelton Guffey and he's no longer on the case. Mr. Guffey was given some time to get an attorney and I haven't been contacted by one.
How much time was he given last time?
Yeah, I don't know if, I think maybe it's like 15 days or so. But we haven't heard from Mr. Guffey. We were needing his pay stubs and we're also just wanting to set a date to have a custody hearing, just the final hearing on it. And so
Well, submit an order giving him 10 days.
to get an attorney.
I'm not involved in the case, but he showed up at my office and signed a agreement over on the child.
Okay. Yeah. And so, I mean, that's really if he, with that signature, I mean, we're still prepared to just move forward, just getting a date on
Did he give you information to calculate what the arrears
We
are?
had previously calculated based on how it's working, $800 per month plus $200 towards the arrears.
yeah, and we're fine with pursuing that, just using that as the,
I'm
yeah.
sure you are.
We're fine with that, but we do just need a final hearing on custody, so. But it's hard to schedule with.
What's happening with the custody now?
My client there's 2 children and she's got both of them just with all the time.
Is he getting any visitation at all?
He had been with the son, but then he has a
The answer would be
companion.
no. The answer would be
Yeah,
no.
answer's out.
Okay, without going into
Correct,
underlying
yes,
facts
yeah,
and things,
no.
okay.
Not right now.
Well, we'll schedule it here. Let's schedule it on the afternoon of October the 8th. I'll make sure. Schedule on the afternoon of October the 8th. And you serve notice to him.
I will. Is there a
Yeah.
specific time to do?
Well, we usually finish around, let's say at 2.
Okay.
Okay, 2:00. Okay, and I would suggest you might get the sheriff to serve him rather than trying to mail it under arrest.
Okay,
Okay?
I'll go. Thank
Okay,
you.
thank you very much. Hammonds versus Hammonds, motion for default. Have you heard from Mr. Hammonds?
No, Your Honor, and she hasn't had contact with him for
You know
about a
where Mr.
decade now.
Hammonds is?
Do it.
You know where Mr. Hammonds might be located?
No, I do
Is
not,
he out of
sir.
state? Did he leave? Do you have any rumor? You just completely.
I don't know. All I know, he's a registered sex offender and he ain't registered for 2 years. They said they checked the address where he used to be at and he's not there. So I don't know where he's at.
Okay. Well, so you want a hearing on what aspects after the default?
They have no property or debt to be divided. The only issue is the minor child. And he hasn't had contact with her since she was an infant. And she is now 11.
Well, let's do that on October the 8th and do that at 1:30. I have another hearing. It starts at 2. So it shouldn't take very long if he's not present, and do your best to serve, okay?
October 8th at
1:30.
1:30. Thank you, Your Honor. That's all we have. Maybe excused.
Sure. Yeah, I'd forgotten about y'all's case. Y'all want to come up? I'm sorry. You have that file? You have a-
Just like an approach.
What do you have? Just hold it and I'll let her do the signature.
All right.
Y'all both want to come up here? What's the number of the case?
24 CR 52.
Criminal case.
52.
Yeah, 52, Isabella Costado, right?
Probably won't have that same microphone.
Case call Commonwealth Kentucky versus Isabella Costado, 24 CI 0052. Are you Isabella Costado?
Yes, sir.
What's your year of birth?
2000,
Last 4 digits of your social security number?
5160.
I understand that you wish to enter a plea today.
Yes, sir.
Is this going to be a felony plea is what it is?
Yes, Your Honor.
Okay. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything. You have a right to be represented by a lawyer at all stages of the proceedings. You have a right to cross-examine any witnesses that come in front of you. You have the right to subpoena witnesses and have process issued to compel their attendance. You have a right to require the Commonwealth to prove that you're guilty beyond a reasonable doubt. And if you lose, you have the right to appeal. You understand that, all those rights?
Yes, sir.
Okay. Now, in this particular situation, I want to ask you a few questions about your status here today. Are you under the influence of drugs or alcohol right
Yes, sir.
now? Do you understand what's going on here today?
Yep.
Okay. And your mind is clear. Have you had plenty of time to discuss this matter with your attorney? And are you satisfied with her advice? Have you had plenty of time to review the evidence in the case? You feel like you're fully informed about the case? Okay. Now, in this particular situation, have you had an opportunity to go over the plea agreement with your attorney? Okay, you're familiar with that? Okay. Now I'm going to ask the Commonwealth to announce, if you'll step to the left, what's the Commonwealth's recommendation in this case? If you'll step behind the podium here.
On 2 counts of wanton endangerment, 3 years in prison each count. Fleeing and evading police first degree, 1 year in prison. Possession of
I'm
drugs.
sorry, y'all are keying that mic, okay? They're very sensitive. Okay, thank you. Go ahead.
Fleeing and evading first, 1 year. Possession of drug paraphernalia, 12 months in jail. Possession of marijuana, 30 days in jail. All counts to run concurrent for a total of 3 years. the Commonwealth will recommend supervised probation with at least one condition that the defendant be assessed for substance abuse.
And do you want to go to the specialty court? Is that part of the agreement?
Yep, just for the SSC assessment. I think, is that what we're talking about?
Yep.
Okay, so that's why I told her I want to make sure we're on the same page.
Okay, you can come over here now. That's what your agreement was? It's what you agreed to do?
Yeah.
Okay, you realize that after you enter this plea, you'll be a convicted felon. And if you have any other felonies in the future, the persistent felony offender law would allow you to be charged and have any penalties increased because you're a convicted felon. Now, there wasn't a DUI or under the influence sort of situation in there, okay? Okay, is that your signature on the docket? I mean, on the agreement there?
Yes.
Okay, Counselor, do you have anything else that you would like to say about this? Let me see this up here, so thank you. Anything else?
No, Your Honor.
Does the Commonwealth like to say anything else about it?
One other point, the Commonwealth will move to dismiss driving with expired license and reckless driving.
Okay. Okay, and you've notified the any police officers or other potential victims under the law, and that they're all satisfied with that. Well, I'll accept the plea order pre-sentence investigation report to be done by probation and parole and have you reappear here on October the 8th for sentencing. Probation and parole officer is right over there. You need to make an appointment with him to give the information. I suggest you be candid with him and get prepared for the supervised probation, okay?
Okay.
And I will assess any court costs that might be done at that particular at sentencing, okay?
Just that'll be at 9 o'clock as well. Is that correct?
9 o'clock
9
or
o'clock.
as soon thereafter as you may be heard.
Right, I understand, Judge. I just want to make sure that we're all here at the same time.
Yeah, that'd be Central Time, God's time.
God's time. Okay.
Okay, thank you.
Thank you, Judge. Thank you, Judge.
Have we done Hamilton versus Harlow yet? Yeah. Such a lengthy motion that we have here. I didn't know, like one sentence. What do y'all have here?
It is a pretrial conference. Actually, it's a motion to get a trial date. I'm sorry, we came back to get a trial date. We had made this motion a year ago. We renewed it. We are at a time where we are ready to get a trial date. All discovery has been completed with the exception of one deposition that we're working on scheduling.
What kind of deposition is that?
It is a deposition of their expert that they have disclosed in this case, Dr. Timothy Chris.
Okay, when do you think you might schedule that?
I got the email on the drive down here. We've already emailed him and I'll call him if I don't hear from him today. I don't think it'll take him too long to get a date.
What are going to be the issues to be tried here?
Damages only. I believe that the answer had a liability defense, but we're waiving that. It'll be just damages. I believe they have a question on the witnesses. I know they have one doctor who's already been deposed via video deposition.
Have y'all tried to mediate this?
We have, Judge.
Who was the mediator?
Who was the mediator?
Did it get mediated?
Yeah, it was mediated. It was mediated early on before a guy took over the case. I'm pretty sure it was Rick Walter out of Paducah, Kentucky. And Judge, here's the issue. My client's had a cervical fusion. He's got $100,000 in medical bills. It's a clear liability case. He has a future life care plan that we have in this case. The defendant only has a $250,000 insurance policy. We've demanded limits. We believe it's a limits case. They do not believe it's a limits case. And so, we're going to have to try this case, unfortunately, because his medical bills,
eat up about $100,000 of that policy, so.
Between the medical bills and the attorney's fees, he won't have much left, boy.
Well, we're probably gonna pursue a bad faith case, we'll see.
And Your Honor, I think the only other thing, like she said, she wanted to take the discovery deposition, Dr. Chris, we have no objection. I think there will be some pretrial motions, a couple in regard to the testimony of Dr. Timoney, who is the doctor who they deposed, and then one, probably a couple motions in regard to Ms. Lanton, who is the life care planner.
I can't hardly hear you speak up.
Sorry. Pretrial motions that I'm aware of.
That's a life care plan?
Life care planner, and then I think a couple minor issues on Dr. Timoney, who was taken by video deposition. And just to clean up the record on that, I don't think it won't take too long.
I'd sure like if you ought to clean this stuff without me coming back up here again to do it, because I can set you a trial that you want, I assume you want a jury trial.
Yes.
Yeah, okay. Well, it won't take long to get one. It's not a multiple month sort of thing. Can this case be tried in one day, you think?
I think it'll take us two with
Yeah, with the
the,
jury selection problems?
right.
You'd be surprised how quickly we try cases here.
No objection to that whatsoever, Your Honor.
Yeah. Well, let's just, I tell you what, before our next rule day, which is now October the 8th, why don't you call my office in Burkesville
Okay,
and we'll have your calendars with you and we'll set a trial. You'll know more then about whether there's any problems with this deposition or not. If there's not any problem with the deposition, as soon as y'all reach an accord that there's not a problem with the deposition or no other problems that you need to hear me be heard on the 8th, we can set a trial without you coming back over here again. And we'll give you 2 days and it won't be that many months out.
okay.
Sure, we were hoping for January actually, so that's fine. If there are any motions.
Well, I mean, I can give you January dates now, but you haven't told me for sure that you're not going to have any problems there. I don't set dates until everybody's ready. And I want instructions from both of you. We got this order that I sent. You've seen that little.
Yes, and the instructions have been filed from both of us.
Both of you.
We both file our trial brief.
See, I don't see those until people tell me that.
We read your order very carefully, both of us, to make sure that we would have everything, because we did not do that last time with all candor,
Well,
so.
we're ready. I'm ready to go when y'all tell me.
Other than a hearing on those motions that we mentioned, I can't see anything else that I could get those done and.
You're talking about motions and limine
Motions and
objections.
Well,
Okay.
I want to do the motions in limine because if there are motions in limine that are granted, it could really change the strategy of one party or the other as to whether they need additional testimony. If their expert witness is found not to be credible or admissible, they might want a continuance to get somebody else. So, I mean, when y'all get ready, everything go, I can pop you one in 45 days. I guarantee you I can.
Okay.
Okay.
I'll get
Thank
those
y'all
filed.
very much.
Thank you, Judge.
You need someone to tell you how to get out of Monroe County?
No, I can
I
find
think
my
you
way,
still
right
remember-
through Sulphur
still
Lake.
remember?
That's God's country.
Well,
yeah.
everybody else remembers how to get out of Monroe County. More of you ought to forget how to come here. Okay, good seeing you. Perkins versus Hunt.
Judge, we're going to be just submitting an agreed order in this case.
Oh, God bless you
I didn't
today.
figure that'd be an
Yeah.
issue.
Okay, is that it? That's it. Okay, well done, both of you, well done, well done. Farm Bureau versus Michael Pitcock.
Good afternoon, Judge.
Hello?
Alan Bertram with Bertram, Cox and Miller, attorneys for the plaintiff, Kentucky Farm Bureau. It's a motion for summary judgment on an automobile accident case.
It's a subrogation claim here?
Yes, Judge.
Yeah, it seems like y'all got a lot of them lined up here. They decided to start going after something.
Yes, Judge.
Well, is Mr. Pitcock present, Michael Pitcock present? If not. Okay, well, I guess you submit, once you electronically submit an order then, okay, I reviewed it last night. All right,
Yes, Judge. It looks like we tendered a judgment with the motion.
I didn't, did you electronically file it?
Yes, Judge.
Or we'll go ahead and issue it then.
Thank you, Judge.
My staff lawyer who does that is out right now. She had to leave early. Okay, now I think you got the next case versus Tammy Smith and Barbara Hutchison. Is that correct?
Yes, Judge. This is an automobile accident case, and Bertram Cox and Miller represents the plaintiff, Kentucky Farm Bureau. Looks like this gal was driving without the registration or insurance, and they had a car wreck.
Yeah, I read it. Is anybody here on behalf of Tammy Smith or Barbara Hutchison? Not, I'll do the order, okay? I hope this makes everyone's insurance go down since you're doing all these subrogation claims.
I hope that'll reduce the losses, but boy, there's a lot of these cases, Judge, a lot of car wrecks in Kentucky.
That's right. That's right. Okay. Do you have any other cases on the docket?
No, Judge, that does it for us. If I could be excused, thank you.
Have a blessed day.
Thank you. Thanks for your staff's help getting this done by Zoom.
Yeah, there's no problem. In the marriage of Jesslyn D. Ann Graves versus Christopher Neal Graves. Okay. Yeah, I read this motion here. And the allegation is that your client violated the terms of the previous order. Is that correct?
That's the allegations. That's correct.
Is there any other allegation other than that?
No, Your Honor, and this was somewhat hastily put together. I realize that. The incident that apparently happened last weekend, obviously very concerning to my client. I'm happy to elaborate, but it's simply put, from what Mr. Graves' mother reported to my client, she was supposed to be supervising during his weekend periods. It's clear she was not for at least a period of time, and it's also clear that he and his mother, had a terrible physical altercation.
Well, it sounds like to me that we need to take some testimony on this today.
Okay, Judge, if I could point this thing out and talk to Mr. Davenport about it, there's not been a violation of the visitation. If you look at the separation agreement and also included in our mediation agreement, we mediate this case.
Yeah.
The only supervision is during his overnight parenting time. This was not overnight parenting time. This happened on a Saturday, this incident with his mother. His mother actually stayed all night with him Friday night for the overnight parenting time, had the child Saturday. Of course, grandma ended up with the child Saturday night. So we negotiated that. I know Mr. Davenport takes a now when I discussed it with him, probably he can tell you what his position is, but I think he says the overnight parenting time is the whole weekend. We were specifically talked about that. That's why it says overnight. Otherwise, it would say the weekend time is supervised.
And Your Honor, I commended Ron for that interpretation. I'll call it creative. At least in my practice in 2 decades, in numerous jurisdictions, I would submit to you when parties are in order state overnight parenting time, those are the periods of overnight time that Mr. Graves has. So he has 2 types of periods. He has non-overnight, which are weekday, I think like 5 o'clock to 7 o'clock or 3 o'clock to 6 o'clock when the child's returned. And then per their agreement, he got overnight periods, which were alternating weekends. And our interpretation, and I'm confident it's the right one, is that the reason that was done is, frankly, Mr. Graves has a horrible alcohol history. And you may recall, I think the last time we were in front of Your Honor, you looked at him very sternly and said, you got a chance. And the court said, I'm going to give you a chance to have time with your child and prove you don't have an alcohol problem.
Give me some water.
And the reason the agreement is what it was because it's the overnight periods and the weekend periods that he's not at work, frankly, Your Honor, when the binge drinking was a problem.
Let me ask you here, if I take testimony here today about this altercation that your client had with his mother, did it stem from her trying to stay present with the child?
No,
and
it still
supervise?
hurt. She came and got the child that afternoon about 5 o'clock without his permission. He went back to her house to get the child after he got out of the shower. He wasn't there when he was in the shower when she took the child. So he went back to get the child and he got the child. And then that's when they argued and got into it. And then, ended up later on, he took the child back on Saturday night. And then Sunday morning, he went back and picked up the child and there was actually no words, nothing exchanged. And he kept the child all day till Sunday at 7 when he exchanged with Mr. Davenport's client.
And frankly, Your Honor, my client's position is it doesn't really matter why or who's at fault. I mean, these interactions, when he says the mother is not my client, it's Mr. Graves' mother we're talking about.
Well, it was in the presence of the child is the reason I'm interested.
It was, and this is the
I have
person that's supposed to be supervising. And, you know, my client calls me and is word to death that they're taking up broomsticks and knocking down banisters and.
The mother didn't file any kind of
She did not.
protective order thing.
Sorry. Judge, in response to Davenport, Mr. Davenport, I don't gotta be creative to know what overnight is. Overnight's nighttime, overnight. We specifically said that.
He thinks overnight period means that time periods where there is overnight visitation, but I understand how reasonable minds could disagree about what that is. So it would be your position if they're having a visitation and the child goes to bed at 10 o'clock, then the mother doesn't have to be over there till the child goes to bed.
Yeah, well, she's
Well, I know, but I mean, if we're going by definition, determine what
It's not
overnight
necessarily the
visitation
bedtime.
periods are.
I don't think it starts necessarily at bedtime. It starts a little earlier than that, but.
Yeah, well, I'm going to say that from here on out, it starts on those weekends where he has overnight visitation. Okay, and I'll redefine it. I can understand how he could have read it differently, so I'm not going to blame him with it or anything. It was either very artfully worded or.
It was poorly worded because I'm
was
telling you
it?
at the mediation, that's what we agreed to.
Well, I know, but it could have been very artfully worded too, if somebody wanted to accomplish what you say. So, but in any event, I think that I see this, okay, man, you want a time, I'll give you some time to step away and talk with him. If you got to tell him something, it's okay.
Sorry.
No, I'm not saying you got a right to talk to your lawyer, but he's got a right to listen to me too, okay? So he can't do both. Well, he might not be able to do both, but I'm distracted, okay? Okay, so here's what the deal is. The reason I ask about this other violence is there's obviously something else going on here where the mother goes, his mother comes over and snatches the child. And that's not her fault, it's not the child's fault, and they come back over and they get some kind of confrontation. So it would appear to me that I don't really want the child over there unless both of them are there and they're commensurating with each other until some reason is given to me why he doesn't have to have supervision. And when people start talking about breaking out doors and glasses and stuff like that, kind of throws a red flag up to me. I mean, I see people that deserve cussing, but I've never seen a glass that deserved breaking.
Judge, it happened when he took the broom from his mother when she was trying to pop it.
Well, I know, yeah. Well, whatever, it's not anything that this child ought to be around if there's any kind of violence like that going on. So if you've got a problem with your mother intervening with what you think your rights are, you need to talk to your lawyer about that, and he needs to come and make sure there's somebody else that she's removed from any involvement if y'all can't get along with each other. You know what I mean? You just can't self-help yourself like that. That's why you get these big town lawyers come over here and he knows how to handle it. So if I'm going to restrict that visitation to the mother being present on those weekends where he has an overnight visitation. Now, is there anything else that you got?
Judge, I will tell the court, as part of this overnight, when this case first started, he had an assessment at Life Skills for the drug and alcohol system.
Yeah.
They weren't satisfied with that. So in mediation, we agreed to have another assessment. As part of that, before he had his assessment, Miss Graves wanted to go in, I guess, and bash him to the assessor so that then when he went in, and the assessor sort of knew the whole story. We tried to get that set up. We haven't done that. I don't know if Mr. Davenport was gonna find out. He was gonna go tomorrow. He signed all the papers for her to come in and tell whatever she wants to tell. And if once he complies with that assessment and follows whatever recommendations are, then this restriction is lifted. But we just need to
Unless
get
there's
that done.
something that comes from the report of the assessment.
Yeah, which he's gonna have to follow the recommendations.
Yeah.
And it would stay restricted until he's satisfied that.
Ron's right about that. I don't know if he's posing a question, but that is the process that was agreed upon.
Okay, when are we gonna accomplish that?
Well, and I'll tell the court, I don't think there's any disagreement about this. Both parties had difficulty with this facility understanding. They basically told her they couldn't talk to her. She tried to do this 3 times. So they've now, I think they understand he signed some type of release that satisfies this entity.
The confidentiality.
Correct. And so.
Is this do they even have HIPAA stuff there or something at this place?
Right, it's a counseling service there.
I didn't know where counseling services had a HIPAA or not.
I don't know, but they want.
I went to a chiropractor yesterday. He had HIPAA, so I didn't know what.
They
wanted to sign, so he signed it.
But she hasn't been there yet because the first 3 times they wouldn't talk to her. So she still has to go do that. But this all got alleviated just in the last few days.
How old is the child?
3.
Oh, this child's 4.
I'm sorry.
And that child that she got into it with was 3. 3 and 4-year-old is what got this youngest upset. She got hit with a swing. Plane.
It's a long time to have to deal with each other. You know, both of you. It's a long time. So are you in a new relationship of any kind? Are you also? So you are with someone though. Okay, you are too. Do y'all have children by the new relationship? Do you have any children with the new relationship? Well, then probably both of you have all the children you're gonna have probably unless you adopt. Maybe, who knows what God will do. But I don't know. I think that there needs to be some kind of anger situation. There's obviously a lack of trust here. You know, obviously a lack of trust, maybe deserved. It's, I don't know, these alcohol and drug situations, you see, I almost see as many people come off of drugs as I do alcohol. Alcohol is extremely difficult to come off of it. I'm not saying you're not all right now, okay, because I don't know. But there's always a reservation by people on the other side if they've lived through that, even if both of them were living through it, I don't know, of trusting. So y'all ever talk about any family counseling as far as how they get along with each other? This person here is to do an assessment of what this new group.
Drug and alcohol.
Drug and alcohol. Well, I think they probably need some more help rather than just drug and alcohol myself.
They make it, we see family counseling a lot or co-parenting, what they call co-parenting.
That's right.
counseling.
That's right.
And I mean, my preference, Your Honor, would be get the results back from what he's done and see what they tell us
I
or
think
what he's
that's
getting ready to
true.
do.
And then you think it, then you can decide whether you think it's fixable or not, right?
Correct.
Okay, that's reasonable. But I think both of you need to do some thinking about the long term. My God, it's 13 or 14 years. And as the children get older, these interactions going being at the same places for ball games or cheerleading. It's a little girl child. Hopefully she's gonna be a ball player. That's what I was afraid of. Well, you'll get your time to hand her a ball there, okay? Is she gonna be a Monroe County cheerleader? Well, they got a good history of it. I know they do. It's a little girl thing, but now I tell you, they've had some good basketball players and pole vaulters and other athletes here too. So maybe softball, golfers, killer, and the Western pole vaulter. I mean,
It's from Monroe County?
Absolutely,
Did
she
not know
was.
that.
Yeah, absolutely. We got a doctor here that teaches these kids about pole vaulting.
I've heard about him.
Well, I'm telling you, what was the little girl's name? Yeah, but what's her name? There were 4 of the Turner girls. 2 of them played college basketball, and the other one was a pole vaulter at WKU and did real well. Okay, well, if you have any trouble with that company, come back. Don't wait till another rule day.
Yes, sir.
Call back.
Right. So we just, we put in the thing, she would do that as soon as possible. So If she can get that scheduled now, then he'll get his things.
Get it scheduled
He'll cancel
get
tomorrow.
it scheduled within the week and try not to schedule it out of more than 2 weeks out, okay?
I think your honor has denied the motion to suspend the supervised visitation, but clarified that it is to be supervised on all of during his weekends. Is that
That's right. That's right. Until we decide something else, okay? And the reason,
That'd be until if his assessment comes back pursuant to our agreement, then the supervision is lifted.
If I don't follow.
well, there's not gonna
Well,
be,
unless he
it's
files.
not gonna be lifted until I lift it. I want to see what the assessment is and
Come
I'm
back.
sure, and you know, if you send an agreed order, doing something, that's fine. If not, I'll hear you over here, okay?
Your honor, I'll send an order to him, have seen if that.
That'd be great.
Please.
Thank y'all very much.
Thank you,
Judge, that's all of my matters
Okay,
today.
yeah. Okay, yeah. Is the next matter, is there anything else on the docket that's not confidential? What do you have?
And geoscience consultants versus James Driver et al. Mr. Stevens is on.
I don't know whether I have that or not. I don't remember looking at that.
It wasn't on the docket sheet, but it was on the KY Dockets website.
You have that file? I didn't, as I was,
Judge, it's their motion to compel discovery.
there you go. Everybody's getting
How
along.
much time would you need?
10 days.
Okay.
He submitted an order.
The problem is I have 2 clients and one of them is very responsible. And one of them, we don't know where she lives. She won't answer the phone number we have. Her boyfriend picks up and won't let her talk.
And this is, I work for Brian Pack, and so this is his case. I'm just filling in today. He also had a motion to set a bench trial. I don't know if you want to do that today or to wait till a later date.
Well, what's the case going to involve? What facts are you going to try?
Judge, this is a mechanics lien filed by Geoscience. They rehabilitate old gas stations, you know, the recover the tanks and everything.
Brownfields, kind of thing.
Yeah.
Tanks and brownfield.
The Commonwealth of Kentucky issued a check, I'm using round numbers here, $20,000 to my client's father's estate 3 or 4 years ago. And he was in Tennessee. His estate was. Geoscience never filed a claim. I don't know. I was not involved in that case. They just took the check, put it in the estate, and divided it up as an asset of the estate. Geoscience says it's for work that was done up to, now they filed a claim against my client for $27,000, which includes the $20,000 the state's already paid somebody else.
Who was supposed to pay for the cleanup?
Supposed to pay for what? Sorry.
The cleanup. Who was supposed to pay for it? Did this, who owns the property now?
My clients inherited it from James Driver's widow. And my clients owned it.
They own it now?
No, they have sold it. We've filed the bond to stand in place of the mechanics lien so that they could transfer the property while this is pending.
And so it was one of these brownfields or tank situation that was identified by the state that needed to be cleaned up.
Correct.
Now, there's a fund to clean it up, okay?
Yes.
And that's where the money came from.
Yes.
Now, and who cleaned it up? Your clients?
Geoscience can, yes.
And you're saying that they incurred $27,000 worth of cost or thereabouts, somewhere around there, and the $20,000 it was supposed to pay for it went to somebody else.
Yes, and it's convoluted because it's like the
I
state's
noticed
supposed
it
to
right
pay.
off. I noticed it was
Yeah, the
convoluted.
state's supposed to pay for it, and I think the check went to the estate, and the estate was supposed to forward it to Geoscience Consultants.
That was not my estate. This was a Tennessee estate.
Yeah.
My clients did not own the property at that time.
Yeah, because the people hadn't died yet.
Correct.
Well, you can't criminally prosecute them for sure. They're dead, right?
Correct. And
What was the estate worth at the time?
Which estate?
The people in Tennessee.
I have no idea.
Of course, this property didn't go through the estate. It went through intestate succession, right?
No, they had.
Was there will?
Mhm. And because the will from Tennessee, and it's a convoluted deed even, that it transferred it to,
I don't know those details.
yeah, it transferred it from the two surviving heirs to one of the surviving heirs, which was my two clients' mother. I believe the person who died in Tennessee.
Have you joined the state?
No.
Mr. Pack filed, he included the bonding company, which they have not responded whatsoever to this lawsuit.
The bonding company told me to handle the case. They would not hire an attorney. All they're gonna do, they've got the money. You know, my clients, it's a $27,000 claim. My clients have had to put up $54,000 from the estate with the bonding company, plus pay the premium every year.
I'm trying to figure out whose responsibility it is to pay at least the $20,000. Don't you think the state had some obligation to tender the money to the person that did the work?
I don't think I think they tender it to the landowner, and then the landowner is supposed to.
Have you looked, you or Mr. Pack looked that up?
I have not. I don't know if Mr. Pack has or as well. So,
But that is, the crux of the issue is the $20,000 of the $27,000 that was incurred, my client has absolutely.
I understand that. They didn't get it.
No, but my client didn't own the property when that was.
I know they
paid, so-
didn't get it. They didn't
Yeah.
get the money and they didn't own the property.
Correct.
But they did benefit from the property being cleaned up. Ultimately,
I don't know if they did or not,
was
because
the property cleaned up?
no, it is still an ongoing mess. Because the new landowner,
services were provided.
but not to my client.
On the land, this is the
Because
NREM. They're
that-
claiming it's
what-
the NREM.
And I don't know, and I just, and forgive me, I don't know the details, but if geoscience consultants perform services and build the estate, and the state was paid the estate, and the estate's supposed to pay geoscience consultants, our client didn't get their money. Somebody got it,
Well,
spent
you
it,
know,
did what?
there are a lot of people that didn't intend to not, they intended to get their money and don't get it, but they haven't filed the correct papers to get it, and they didn't secure their position. So did they file a lien on the property when they provided these services?
I don't know the details of it.
They did not file a lien until after my client had owned the property for 2 years.
See, there's some statutory problems with when liens are provided based on when the last services were done. And that, you know what, if you ever do any lien property, I've done a lot of liens.
And that is an issue we've raised, that the mechanics lien can only impact what was done within the time, because they had already submitted a bill, an invoice to the previous owner, why they didn't get paid from the previous owner is not our fault. But they weren't contracted with us.
Well, here's the thing about it, what bothers me is that this is a claim that has to do with services that were provided to a property. And if someone ups and sells a property, one of the things they assume, and we all have done title opinions too, it would be any sort of statutory lien. You exclude anything that's not of record, you only do record. And if there's some work that has been done and a lien can still be filed, that person who did the work can protect their interest by filing a lien, no matter whose title the property's in. So I'd like for y'all to take, I'm ready to try the thing, but I'd like for y'all to take a look and give me a little law on who the state paid, you know, and really the state paying those people might really be irrelevant, because your clients provided the services to that land, and the fact that that estate did not pay for it like they were going for might extinguish your claim if you don't have a lien filed. That's what I'm looking at.
No, they never filed a lien against a mechanics lien against the previous landowner.
Well, that's what I'm saying. The
work
mechanic
they did
lien
on
has to do with the work that was done on the property, regardless of who the owner was. And if the owner sells the property, if it's still, the lien period is still open, the new buyer takes it subject to any potential lien that might exist because of the work that's done it. Now, that's my understanding of the lien statute. You agree with that?
Real estate closing banks, they make the seller sign a statement that there is no possibility of those type of liens. But this was through inheritance, so there was no statements of that. But
Well, okay, what do they do if a person signs one of those that there is no liens and they're lying about it and then they die. There's no money still. So there are a lot of different ways it could go, but you could talk about the way it usually goes. But in this situation, the company that provided the services, in my opinion, was remiss by not filing a lien to protect the work that they'd done on the piece of property.
And they should have filed a claim against the estate because they knew that that estate had received the money.
Well, I don't know whether they could file one against the estate that would have affected the ownership of the land if the lien.
But that once the state issued that $20,000.
Then they would go under just a contract law, a quantum merit thing, and then you suing somebody that was in Tennessee. If the property was already gone.
The property was not gone.
By the time they would have filed suit, the property would have been
But
gone.
they could have filed a claim against the estate for the services that were provided for the benefit of.
Well, there wouldn't even be need to have done that if they'd have filed a lien.
I agree.
You know, but so, I mean, I'd like for you to look, and I'm sure you'll send Mr. Pack back over here the next time. I said,
Definitely.
I love it.
That is the truth.
Mr. Pack and I had a 2-day bench trial in Barron County a couple of months ago.
Well, I guarantee you won't have one here.
With Ken Meredith, and there was a 3-party.
Oh, yes.
I bet that was a pleasurable experience for all. Okay.
Nothing about that has been. And
So,
it's-
okay, what are we gonna do to advance this case here?
Judge, I will get him his discovery within 10 days. We've got them typed up. We've sent them to one.
Okay, do the discovery, and what I wanna know is what theory that y'all are going forward on that you can collect this because and what the lien period was. And how you can sue subsequent owners, even if the subsequent owner was by will. Now, there might be some tracing.
My client signed a contract with them,
With who?
with Geoscience, and we're willing to pay for the part that was done while we own the property. That was performed under that.
Have you read that
contract.
contract very closely to see if they
No,
assumed?
and we've got Mr.
Assumed,
Anderson.
where they assumed the responsibility for any work that had been done prior to that?
This was
Does it
for-
exclude it?
Well, how could they encumber the property before they owned it? They just said, you will perform the services necessary to finish remediation, is basically what the contract said. But then they sent the bill for the entire amount of it.
Okay. Well, you could look at it that they inherited the property, but they received the benefit and decided they were gonna pay for what remaining work needed to be done, and they were unjustly enriched by the improvement of the property. A lot of things you could look at it. This would be a good bar exam thing, you know.
Judge, it's been way too long since I took the bar exam, and I will never.
You
take
still
another
don't
bar
have
exam.
like, you don't still have post-traumatic stress syndrome. My dad, may he rest in peace, when I was back home, I said, Dad, I still have bad dreams about law school or college. I went to the class and they moved the class and I couldn't find it. And the final was going to be that. I said, how long does it take to get over that? And he said, you'll have to ask somebody older than me.
When I took the bar review class, and I remember there was almost a half page of material in the bar review booklet, and the bar review proctor said, don't worry about this. They've never tested over this. They can't test over it too. And guess what our question
Oh,
was?
yeah.
And so
Well, the other bad thing that happened when you go out and everybody gets after this, man, I didn't think we'd have a conflict of law case. I said, hell, I didn't see a conflict. Okay, well, thank y'all very much. And I'll wait till you look at that. And would you kind of look at that and just tell me your theory a little bit more besides just a complaint?
So we'll wait for your discovery
And
and
then
then
and
you want
Mr.
to
Pack
say,
and I will sit down.
okay,
I know, he's been waiting for other cases to get done before
Gotcha.
we pursue this very hard. I know.
okay. And then
Okay.
talk with him about that, about the theory. Do you want anything filed, Your Honor?
Just an order that I have to get it within 10 days.
Okay,
We'll
thank
hold
you.
off on the bench trial scheduling.
I can do a bench trial with very short notice if you got all your stuff here, you know. It
Okay.
appears to me that the factual situation is going to be easily established, except the cost of what y'all did. The issue that I have with it is going to be whether you need to have a lien or not, and whether or not you have have any claim against a subsequent owner, even if the owner took it by will. I think the facts are, you're not denying the facts. The fact, what the difference in the facts that y'all got?
Difference in the facts is we only think, we're responsible for work that was done.
That's an issue of law.
Yeah.
That's not, the fact, the facts are gonna, there was stuff done after your people got it by will. There was stuff.
Our immediate predecessors in title got it via will. And then they owned it for a year and a half, 2 years.
Sold it to your client.
Then she just passed away. And my clients then got it by intestate succession.
I thought you said one of them got bought out.
That was the immediate predecessors in title.
Yeah, so you got two situations. You got a will, somebody buying a will out, somebody dying, and then intestate succession. So you got like a tracing problem, it looks like to me, to find out whether you need to have a lien or not. So you probably won't disagree with those fact situations. So why don't y'all sit down and see if you can work the fact situation out? And then we might just submit the situation memorandum on what the law is. Okay. Okay, thank y'all very much. Is that it?
Thank you, Judge.
Yeah.
Thank you.
Is that it till the confidential matter?
Until the confidential.
Okay, let's go off the record. It's microphone, it's really, I'm sensitive up here.
Yeah,
I think you're so high.
Here and the part of it.
It goes like that. What is the confidential? It's her, what is you? I know who allowed it around here. Yeah, don't do that, I'm too long.
That's that I think.
$2 on the way, and I get to go to Walmart. It's like this in Berkeley, it's like this in civilization. You know what? I always say, I always say,
That's why.